Check. Hello and good morning. I'd like to convene the public hearing of the Committee on Children today. It is morning, right? Yes, 11 a.m. It's still morning. Thank you all for being here. As usual, we have to do our housekeeping announcements. In the interest of safety, I would ask you to note the location of and access to the exits in the hearing room. The two doors through which you entered the room are the emergency exits and are marked with exit signs. In the event of an emergency, please walk quickly to the nearest exit. After exiting the room, go straight and exit the building by the main entrance or follow the exit signs to one of the other exits. Please quickly exit the building and follow any instructions from the Capitol Police. Do not delay and do not return unless and until you are advised that it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room and stay away from the exit doors until an all clear announcement is heard. As usual, I will comment that it is a sad state of the world that we have to talk about what happens in case of a lockdown, and we should all be working towards resolutions where that never happens again. With that, I'd like to turn to my co-chair, Senator Mar, if you'd like to say a few words.
Just good morning, and thank you all for your concern for children. It's important.
Absolutely. Thank you so much. And let's get right into it. Commissioner Durantes, you are the first person up today. Hi. You are not, but you are still welcome here.
Thank you and good morning, Senator Mar, Representative Linehan, to Senator Seminara and Representative Dauphinais, and the distinguished members of the Committee on Children. My name is Deputy Commissioner Jody Hill-Lilly, and I am filling in for Commissioner Durantes, who is having some technical difficulties and offers her regrets for not being able to be here this morning. I am accompanied by a team of subject matter experts who are here and ready and willing to answer any questions that may arise this morning. There are 6 bills that I will testify on that were proposals offered by DCF. I respectfully request that the committee acts favorably on these bills. The first bill is RB 1006, an act concerning urgent crisis centers. Last session, the Lamont administration and the General Assembly made children's behavioral health a priority. A new level of care was created called the Urgent Crisis Centers that provides emergency treatment to children who are experiencing acute psychiatric episodes. Urgent crisis centers should help to alleviate the burden on traditional hospital emergency departments, which have seen an influx of children struggling, as you all know, with mental health concerns. These centers are outpatient, non-residential behavioral health clinics operated by private providers through contractual agreements with DCF. Public Act 22-47, a comprehensive children's behavioral health law, defined urgent crisis centers in 2 insurance statutes as being licensed by DCF. One of the providers indicated that they would operate their urgent crisis center through their emergency department under its Connecticut Department of Public Health hospital license. Under the bill, the centers may be licensed by state agencies other than DCF, but will still operate under the oversight of DCF. The department will continue to contract and oversee the service of deliveries by these centers, even in the absence of direct licensure by DCF. The next bill is RB 1007, an act concerning the transfer of certain guardianship subsidies upon the death and serious illness of an adoptive parent or guardian. This bill amends Section 17A-126 to allow for the adoption subsidy for a child that was in the care and custody of DCF prior to adoption to follow the child when an adoptive parent dies. We had an unfortunate situation where that occurred. And in this situation, the parent died, or the bill asked for when a parent or adoptive parent is unable to care for the child due to the incapacitation or serious illness.
Commissioner, just a 3-minute warning, so you're aware.
Okay. The subsidy would follow the child to a successor guardian appointed by the court in competent jurisdiction, ensuring that the child will continue to receive support and reducing the risk of harm to DCF custody. The next bill is RB 1010, an act permitting the disclosure of certain records of the Department of Children and Family to the Department of Public Health. Public Act 21-2 of the June special session requires DPH to license the Albert J. Solnit Center, Children's Center, which is operated by DCF. When DPH began the licensing process, our existing record confidentiality statute, Section 17A-28, created an obstacle for licensing officials to access the documents needed for licensure process. By amending the statute, it will be clear that DPH can access records necessary to carry out licensing these facilities. The next bill is RB 1011, an act concerning minor revisions to the statutes of the Department of Children and Families. The Federal Child Abuse Prevention and Treatment Act, CAPTA, requires states to implement a notification process to DCF when a baby is born who has been prenatally exposed to substance. A CAPTA reauthorization bill was introduced in the US Senate in 2021 that replaces the term plan of safe care with family care plan. This bill makes a change to the corresponding state statutes, replacing references to plan of safe care with family care plans. It also replaces women with pregnant parents to make the language of the statute gender inclusive. We have requested JFS language in our written testimony. The next bill is RB 1012, an act concerning certain background checks and home visits required by the Department of Children and Families. This bill updates the language and statutes concerning required background checks. Current law permits DCF to place child with a relative or fictive kin on an emergency basis when the child cannot remain safely at their current residence. When an emergency placement occurs, all members of the household over 16 years old must submit a background check and fingerprinting. Typically, the relative or fictive kin will then apply to be a relative foster care placement as the department works towards reunification of the child. Again, under another background check and fingerprinting, an additional background check and fingerprinting are required. DCF has historically streamlined this process by allowing the first background check to be sufficient for a more permanent foster care placement. However, the FBI has indicated that two separate checks must occur since they are in separate statutes. By combining the emergency placement statutes, the relative foster care statutes, by combining the two separate let me start that again. By combining the emergency placement statutes and the relative foster care statutes, the duplicative background checks will be eliminated, lessening the burdens on families, saving $88 per duplicative background checks. This bill will also require only household residents 18 years of age and older to submit to the background checks rather than those who are 16 years of age or older as under the current law. This reflects best practice nationally. Most children under the age of 18 do not have a record to check. We have requested JFS language in our written testimony. Lastly, we support RB 1009, an act concerning identified adoptions. We partnered with the Probate Court Administration and private adoption agencies to develop this bill. It updates the language in the identified adoption statutes and revises the probate statutes regarding payments by prospective adoptive parents to birth parents. The committee has our written testimony and others are here to testify to the specifics of the bill. Thank you for this opportunity to testify. Timing?
That's okay. We give the warning just so you understand where you are, but being that you are here at the committee of cognizance of your agency, that it is important to hear everything you have to say. We just give a warning on that. But thank you for being here and you did a really fantastic job. I do have some questions.
Sure.
I have to apologize that I was kind of scrambling to get my stuff, so I don't know if I missed it. In your testimony, did you give any testimony regarding 6645, an act requiring parental notification of certain events by inpatient psychiatric and behavioral health treatment facilities serving children?
I did not.
Does the department have any stance on this, or is this just something that we can discuss at a different time? Being that we're at the public hearing, I don't know if you've been with the department long enough to understand the impetus of this bill. So I'm not sure if you could answer these questions, but are you aware of this bill?
Yeah.
And have Vinny come on up?
Yep.
All right. Thank you. Then if you could just state your name and title for the record.
Absolutely. Hi, good morning, everybody. My name is Vincent Russo. I'm the Director of Government Relations at DCF. And yes, while we did not testify on that bill, we do not oppose it. We understand the best practice. In fact, how it relates to our operations at DCF, obviously we operate the Solnit Center, which consists of the hospital and the two psychiatric residential treatment facilities that are state-run. And as current practice, we are doing that. So from our perspective, it makes sense. We're doing it. So we're good.
I really appreciate that. I just, for the purpose of the people watching today and for the members of the committee, I want to give a little bit of background, if that's okay with
Absolutely.
you. Before the current commissioner came aboard, I believe it was, I want to say 2017, we had an issue at Solnit which was where a finding of immediate jeopardy of harm was made regarding the safety of children at Solnit after the death of a young girl named Destiny G, who was a pregnant teenager who was being released just that day, and that she did not want to leave. And that morning, she hung herself in the bathroom at Solnit. Based on that, this committee has taken on, we did some legislation surrounding that. The department has been extremely helpful. And once we had the new administration, and again, the new commissioner, we came in and we had these discussions, and please then correct me and interrupt me if I'm remembering wrong. We had these discussions about how these things were so important. And in fact, with the commissioner prior to the current commissioner, there had been discussions that in this committee before I was a co-chair, that I wanted to see parents being alerted whenever a finding like that, or whenever there was a death in care. That commissioner refused. And to the credit of the current administration, when the current commissioner came aboard and we had a very simple conversation, you guys put that into place. So the reason why I want to make it clear during the public hearing today is that it's very important to note that good practices happen under good commissioners. But we all know that commissioners don't last forever. So there is a real need to start putting into statute these very important things that our fine commissioner has put into place. And essentially that's what this bill does. So for the benefit of the committee, I appreciate you allowing me to go off on that. And is there anything that you guys want to state on the record for the members of the committee about this bill before we move forward?
No, I think it's best practice. It's the right thing to do, and we wholeheartedly support.
Isn't that amazing how it happens? Just doing the right thing, right? Excellent. Thank you so much. Are there any questions from any other members of the committee? Madam Co-Chair, are you? No? Representative Wielander.
Thank you, Madam Chair. Good morning. I just had a quick question. If you could address the bill, now I wrote it down. SB 1012. And if you could just speak to the changes in the background checks and reassure everyone that changing those background checks does not mean any lessening of safety concerns, I would greatly appreciate that. Thank you.
Absolutely not. We really pride ourselves and make it a priority for safety to be first and foremost. And this in no way, shape, or form lessens our assessment of safety of these homes. It really is duplicative in nature. And the time frame between the checks is so short that it really is costing the state a lot more money than it needs to be. And I will tell you that we have multiple ways to ensure safety happens in a home. And so this, I just for the record want to say in no way, shape, or form minimizes our safety assessment and our process.
I just want to add one thing to answer your question, Representative, and I wholeheartedly agree with the Deputy Commissioner, but there is also a provision in this bill that states that if the licensing of the foster parent does not occur in 12 months, then there will be another check. So we do have a stopgap in there. And just for the record, when we do licensing of foster home placements, the checks happen every 2 years. So it's actually having the time of our normal rechecking family members. So we feel that that provides enough safety to streamline the process, relieve the burden of our families, relieve the state of a little bit of a cost, but continuing to ensure safety is paramount for these kids.
Thank you so much, both of you, for that answer. I really appreciate it. I know the everyone who's watching and has the concerns of safety of children in mind. I really appreciate that. Thank you.
Thank you, Representative. Are there any other questions from members of the committee? Well, that brings it back to me because I now found my notes and I have some questions. Regarding the home visits bill, I think Representative Wieelander, you did touch on some of it, but in the original language that you guys sent, there was no explicit language that there would be a DCF case or a file check on the family before emergency placement. And we just wanted to double check that even though you're not doing background checks in certain cases, there is still the DCF abuse and neglect registry check before any child goes anywhere, correct?
Absolutely.
Right, that's
Absolutely.
extremely important.
Yeah.
And just one more piece on that, Representative.
Yeah.
So the bill does, when we do an emergency placement, obviously it's emergency, right? So we know pretty early on about the background check when it comes to our registry. As far as the FBI background check and criminal history check, the bill does say it has to be done within 15 days, which is a very short period of time in order to ensure that their safety. And obviously in that time, we have a social worker escort the children to the home, do a quick review. And so I just wanted to make everybody at ease that this, when these placements occur, those checks do happen within a very short period of time.
Sure. Okay, thank you. And if there is one more, if you will just give me a moment to pull it up. Let me look at I just want to make sure that the bill I'm talking about is going to be on. Oh,
So while
Mr.
my co-chair is looking for her next question, I would like to just go back to that, what you just said. You said the social worker accompanies the child to the home and then the background check is done within 15 days. So what ensures that in those 15 days that person that the child has been placed with is clear? I mean, how are we making sure that there is safety in advance of that background check coming back?
So we have access to certain information around Child Protective Service, background checks. We can check to see if somebody's on the registry. So there are checks that we can complete immediately. I'm going to have Tina Jefferson, who is our Bureau Chief of Child Welfare, walk you through that process.
Welcome. Thank you.
Hi, everyone. Yes, we have an emergency home assessment process where we can do immediate background checks and child protective services checks on families before the child goes to the home. And it's a really comprehensive process that our foster care division will walk through with the families to make sure that there aren't any immediate safety concerns. And then, as Vinny indicated, a more thorough check is done thereafter.
Okay. Thank you so much for the clarification.
You're welcome.
Thank you very much, Madam Chair. Let's quickly discuss 6640, an act concerning home visits and evaluations by the Commissioner of Children and Families. A couple of questions that we have just to make sure. Telework is part of the negotiated contract with union members. Is that correct?
Correct.
And telework is defined as what in the contract, if you're aware?
So the way we, excuse me, the way we like to describe it is telework is merely where you start your day. And so it doesn't mean that they are not deployed to the field as necessary and appropriate as dictated by policy. So telework is working from home, but it is working.
Right. And so do you have any data on the amount of home visits that have been done via Zoom or Teams or something in a remote setting?
So I can tell you under with certainty that we have been back sort of in full operation since May of 2021, I think it's been. So our expectation is that all home visits are done in person as before the pandemic. There are circumstances, however, where either the family does not want us to come in person or there are some mitigating circumstances. And we do have a process which is required to be followed if a virtual home visit is to be done.
Can you tell me a little bit about that process of the virtual home visits? Are there certain families or situations which a virtual home visit may not be issued?
I'm going to turn that over to Tina, who is day-to-day dealing with.
Thank you.
Yes, and Jody is correct. We went back to full in-person operations when it comes to our interaction with families back in May of 2021. We did have a brief time period, though, where we allowed at the end of 2021, beginning of 2022, when there was an uptick with COVID, we allowed for a triage process to resume, and it was for a few weeks, approved by Deputy Commissioner Williams, just for safety purposes. And the triage process really consists of the program supervisor having to weigh in on whether or not virtual contact is appropriate, or whether or not in-person home assessment is appropriate, which is our normal day-to-day business. And so that's been a good year now, where the only time, and we put it in our policy, the only time that virtual visitation can be conducted today would be if the family is experiencing an illness.
Okay, and so let's just be clear for everyone here that when you say the triage process for safety, you're talking COVID safety, you're not talking safety from abuse or neglect.
COVID safety only, right?
So so what this bill would do is actually spell out now what areas need to be exempted from that. I understand that if a family says, we're afraid of COVID, we don't want you to come in, I could say that at any time, and that is not necessarily, that could be used as an excuse, let's face it. So what this bill does then is put into statute those times when that answer is not acceptable. And so if you look at starting on line 7, it says if the child is under 6 years of age, such child is 6 years of age or older and not enrolled in school or being educated at home or in a private school in accordance with the provisions of section 10-184 of the general statutes, or the immediately preceding visit to or evaluation of such home was conducted by telephonic, video, or other conferencing platform. So it has to meet those standards, correct?
Well, can I offer, oh, I'm sorry.
No, please. I would love for you to offer any input. Absolutely.
Yeah, I just want to offer a bit of a point of clarification. We, a family saying I'm afraid of COVID is not a reason that would deter us from going out to their home.
What if they said that they have COVID?
Now, yes.
Do you,
right.
do you require proof of COVID?
No.
Ma'am, what if I just told you today I have COVID?
Well, it depends on the circumstances. The reason that your family came to our attention, we go out in mask. We've interviewed people at the front door. We do what we have to do when there's a question of child safety.
So interviewing someone at the front door, does that allow you in the house to see if there are signs of abuse or neglect or perhaps drug use around a child?
Not in totality. I think that it's a combination of things, right? So it's usually when we're working with families, it's not one contact only that we have with the family. Like if we're involved with them during an intake, which is an investigation or family assessment response, we're working with that family for up to 45 days. And so there are several contacts that would have occurred during that time. So if one of those contacts was something where that initial contact maybe was outside because the family said that they were ill, but there were concerns grave enough for us to say, we still need to see you in person. We try to work with families to determine the best way to engage with them and make sure that we're assessing the home environment. We've used FaceTime. We've used several different ways to still make sure we're assessing homes. And then we do go into families' homes.
But nothing beats someone coming in and looking around the home and looking for signs of abuse and neglect, whether they are in the home, on the table, the way that a child is behaving, especially when you're asking certain questions, correct?
Correct.
Correct. And can I just interject and say, Representative Linehan, we agree. We feel the best way to assess a family is to go into the home. And so there's no disagreement here. We have prioritized that, and I'm not saying that you're
Right,
saying that
but
we
this
are
bill then
disagreeing.
is helpful to you to spell that out so that there is no ambiguity.
I don't disagree. I would say that is a practice that we are absolutely engaging in. And we feel going into the home, seeing the physical environment, there's no substitute for that. And I think the virtual situations, the virtual assessments should only be used in extreme circumstances.
Right. And so we just need to figure out exactly how to define extreme. And so defining extreme is really kind of close to impossible, because if you had asked me this question, or I had asked you this question 5 years ago, I really probably would not have considered a worldwide pandemic. So that's why we're trying to really work this out. So I want to call your attention then to, and yes, I recognize I wrote this and I'm going to really challenge myself on this, that we said such child is 6 years of age or older and not enrolled in a school or being educated at home or in a private school. I have concerns about being educated at home. The Office of the Child Advocate had issued a report 2 years ago about the crossover between families who have been within the DCF system for abuse and neglect and those who have been removed from school for the purpose of homeschooling. We have said this time and again in this committee room and others that doesn't mean that all homeschoolers are abusing and neglecting their children, but there is a sign that if a child originally is going to school and then is removed, and there is correlation there with families who are abused and neglected and within the DCF system. So does it concern the Department of Children and Families if a family who is receiving services from the system then removes their child or children from school for the purposes of homeschooling? Is that a concern for the department?
I would say we are concerned about any child who is not visible to the community, be it because of their age, be it because of whatever reason, when they are vulnerable. So that is something that we take into consideration, and it is part of our sort of safety and risk assessment. So regardless of the reason that they're not visible to the community, we are concerned when particularly young children are not visible to the community, yet they are in vulnerable situations.
And that's the concern that I was trying to get at in this language. So with that said, would the department object to language being removed from this bill that would exclude children being educated at home? Because we're not looking at necessarily the dangers of educational neglect, which is a huge problem. I don't want to say that if a child is being educationally neglected or that's not an issue. My point is that if we're using the word "or" to list these things, that perhaps we should take out those who are in homeschool situations. Does the department agree with that?
I'm hoping that we would have the opportunity to sort of caucus, meet internally before we take a position on that.
Totally understandable. I will state for the record, that is my position. As well as we do want to say that we're saying a child 6 years of age or younger not enrolled in school. For the purposes of this legislation, school could also mean daycare. So one of the concerns I have is that if a child is going to daycare, are they being carefully watched and is it noted if there are any signs of neglect? So for the record, can you state that are daycare workers mandated reporters?
Yes.
Yes. And do they receive then training on age appropriate signs of abuse and neglect?
Yes.
Great. Thank you very much. And that concludes my questions, but we do have a question online from Representative Sanchez. Representative?
Good morning. Checking my time because I wasn't sure it was morning or afternoon. So my question is in regards to school, we're talking about home visits. When a social worker, and we all know that during the pandemic, many children have missed school, because of the pandemic, and there's many other reasons. But what I'm hearing from some of the schools is that social workers will reach out to some of the parents to find out if their kids, why they've been missing school for a week or 2 weeks or whatever it may be. And they contact them immediately, the day that they're absent. They may not be able to reach that parent. But when they do reach the parent comes out with some excuse that, oh, they had COVID, they were sick, but didn't report it to the school nurse, or, oh, they were on vacation. And sometimes the social workers feel that it's neglect, it's educational neglect where they're not sending their kids. And these are parents that repeat this. And I've also heard that at times they will report it to DCF, but they don't feel DCF does enough in order to get these kids back into school. So what is your take on that? I mean, what is the process right now? And when in regards to that, when a child is missing from school?
So we have clear policy on what constitutes educational neglect. And so we follow that policy to the law, and the schools likewise have their policies on when it is appropriate to report a student for educational neglect. And we respond to those situations as we would any other report on or allegation of abuse and neglect. So we believe that school is paramount for the success of children, and we take it very seriously as we would any other allegation. Again, there are policies and regulations that govern what we can and cannot do, both on the school side and on the agency side.
Okay, and have you seen an increase in calls from social workers or from school systems in regards to getting kids to go to attend school?
I've heard anecdotally, I can't say for sure what the numbers are in terms of educational neglect. We can get that for you, but I will tell you that what we've seen just across the nation is the same dynamic that you're describing. It had been hard during the pandemic to get kids to re-engage in school. And we have yet to really understand the true impact of all of that. So I imagine if we were to look into this and look at the numbers that we might see a trend of educational neglect or kids just really not being engaged in school, but I can't say definitively. We can get those numbers for you.
Okay, thank you so much.
Thank you.
Thank you, Madam Chair.
You're very welcome, Representative, and thank you for those questions. Your expertise is actually very, very appreciated on this committee, so thank you. And it just really brings me to one last question then. Do you, in your professional opinion, and I won't hold you to it forever, but do you think that it's worth it to look into the way we define educational neglect after the pandemic?
My professional opinion, absolutely. My personal opinion, yes. I think we have yet to really understand the impact of the pandemic on society at large. And we know that school is critically important for the development of children. So I would say yes.
I appreciate you stating that on the record, so we can note that, so this committee can go back and take a look at that. And if something is required to be in substitute language in order to really work that out, then we can do that. So I appreciate that information. And seeing, my co-chair now has a question, Senator Mar.
Hi, in regards to school being important for the development of the child, could you please speak a little bit to what kind of development it's important to, just so that we have that on the record?
Well, I will tell you, in the children that we've seen to go on to be successful, I mean, education is one of the more resilient factors that really helps children to thrive. We all know with an education comes an opportunity for employment, employment, livelihood. So education in our mind is the foundation for success for any person, and particularly our children who have been exposed to circumstances that are less than optimal. So we have seen and heard from our youth how important education was to them in retrospect. Sometimes school is what they hold on to. I know for me, that was a big thing too. School was everything for me growing up. And it made the difference, I think, in it can make a difference in the success of our kids and families.
And when you're speaking about education and the development of the child, you're speaking not just of learning, but also the social, emotional components of education and being in the classroom setting, building community within a school. All of those pieces are part of that.
I would say yes, that when you're in a classroom, you are learning to interact with other children. I wouldn't say that, folks who are homeschooling are not able to balance that out. But I do see the benefits, obviously, of being able to interact with other children in the classroom and learn coping behaviors and how to even disagree, all those types of things that we need to grow up successfully happens in the school.
Thank you. And not to put anything against homeschooling, just so much of what we see in terms of children these days is the loss of community, the loss of connectivity, the feeling of being part of something. And so that's why I asked the question. Thank you.
Thank you very much, Senator. And before I send it to Representative Lanoue, I just want to point out while we're still on this conversation, I do have one child who was out all last week due to some crazy virus. And now I've got another child out. He's been out now since Monday. So a lot of what we're seeing is due to the reemergence of viruses that may have not been really out there in such force because we were wearing masks, which tell us masks work, but they still, have some concerns after we take them off. So we need to take that into account in post-pandemic world as well. So thank you. Representative Lanoue.
Thank you, Madam Chair. Good morning, Deputy Commissioner. How are you?
I'm good. How are you?
I'm well, thank you. Just a couple of quick questions here, if I may, if you could, just for my edification. When investigating a complaint of abuse or neglect with a child, could you give me like an idea what percentage of the time it's conducted either telephonically or video or by other conferencing means?
I will give that over to our Bureau Chief.
Hi, good morning.
Good morning.
I don't have any data with me, but I would say the numbers would be really small at this time because we are back to operating with in-person visitation the way we were pre-pandemic.
Okay. During the pandemic period, it was significantly high, where it was remotely doing some sort of remote conferencing?
I know our Bureau Chief of Strategic Planning, who's not with us today, maintained those numbers throughout the time that we were relying on virtual visitation. So I'm sure that's something that we can get for you.
Okay. Could you give me an idea? I mean, during the pandemic period, would you say, I guess roughly was over half of the time it was done remotely, or?
I really don't
Was it
have
was-
that information. I'm sorry.
Okay, I'm just, could you just give me like a Reader's Digest version here of what what the criteria, what the bar is, if somebody makes a complaint of abuse or neglect against a child? When does that trigger an investigation where you guys act on it compared to where you may feel it's a frivolous allegation that has no merit to it? Can you kind of delineate that for me? Where that line is?
So essentially, whether or not a report is accepted is based on statutes. So there's a statutory requirement for acceptance that we follow to the law. Generally, the allegations would have to have an impact on the child. You would have to connect the report, the information in the report, to determine whether or not the child is impacted, whether or not it is a parent, guardian, or meets, is a person who is defined by statutes as the one who is responsible for the child. But those decisions are clearly based on statutory requirements.
Okay, so I mean, looking at the language here in the bill, the proposal we have before us, my concern is certainly issues of abuse and neglect. No child should be abused or neglected in our state. We need to do everything to root that out. Anybody who harms a child in our state, I say lock them up and throw away the key. I take that, I have a no tolerance for anybody that abuses or neglects a child. I want to be very, very clear on that. My concern here with what's being talked about as far as carving out anybody that homeschools a child, who parents decide to homeschool a child, if there is some sort of allegation of abuse and neglect, where it could be as simple as somebody wants to cause that person a problem and it's meritless, they're going to be held to a different bar than somebody who chooses not to homeschool their child. I want to make sure everybody's held to the same standard. I can certainly attest that I know many people in my district. I have many friends who homeschool their children, have homeschooled their children in the past, who are now adults. They have done exceptionally well, have excelled in college, have excelled in life. Last thing I want to do is create a situation where it would encourage somebody could make a false allegation, and it could encourage people to do that. And essentially, they're going to be bound by, essentially, with all due respect to your agency, almost like a full and feathered access to their home, where they'd be bound to a completely different standard than somebody who doesn't homeschool children. I'm very, very concerned about that. But again, I want to make sure that every child, if there is a allegation of abuse and neglect, that all children are treated equally, and make sure we have the same bar. I want to make sure we are not opening Pandora's box here and put in people who homeschool their children at a different standard than people who do not. So I just wanted to make that clear for the record. Thank you for appearing here today. I appreciate your testimony. And thank you, Madam Chair. I have nothing further.
Thank you, Representative. And now for using his one chick card for the second time, Representative Sanchez.
Thank you, Madam Chair, for the second time. This is just a quick comment to the commissioner. I just wanted to commend her department for their outstanding work with fathers. And also your staff, whenever I have a question, they respond quickly in regards to constituents services. So I just wanted to commend your staff and commend you for the work you do with fathers throughout the state of Connecticut. Thank you, Madam Chair.
Thank you, Representative. I also have to agree, because poor Vinny had to answer a text for me at 9 o'clock last night around there. So thank you very much.
And I did.
And you did thoroughly, actually, and I appreciate that. Any further questions? Seeing none, you're off the hot seat. Thank you very much for being here. Next, we have Sarah Egan, our child advocate, followed by Christopher Davis, and then Commissioner Bai.
Good afternoon. No, good morning. Good morning, everyone. My name is Sarah Egan. I run the state's Office of the Child Advocates. Nice to be with you today. I have written testimony that I submitted this morning that speaks to almost all of the bills that you have. So I want to make sure that I'm using the time with me the way you need it. I'll just go really quickly and then I'll stop. The first is, I'm actually going to skip to page 2 of my testimony, which is an act concerning Title IX compliance toolkit for school districts. I really appreciate the committee raising this bill. It's part of a multi-year effort really led by this committee to address concerns of sexual abuse and discrimination within schools themselves. And I wanted to say what the Title IX toolkit is from our perspective is our office has done a number of investigations into what the federal government coins adult sexual misconduct in schools over the years. What we have heard back from districts who have been very responsive to those reviews and findings and have done work on their own to address it is that they need more help in understanding what their obligations are under federal and state law. They want more guidance. They want model policies. They want more trainings for their staff on everything from grooming to boundary setting. A toolkit would pull together best practice, the laws as they've been interpreted by the federal government, the integration of federal and state law, and provide a resource kit for school districts to follow so that they have the tools that they need to comply with federal law expectations around child safety. So we're a strong proponent of that bill. I think that could be really important in the state's efforts to address and prevent child sexual abuse. I wanted to highlight our testimony on pages 3 and 4 and 5 and 6. It's long. Sorry. And it's on such a grim topic, but it's about the reimbursement for suicide screening in schools. And I don't know if folks have seen it, but this week, the CDC released their latest youth risk behavior survey. We'll put something out about it on our listserv. It's a model public health survey that's done every 2 years. Connecticut's a participant in it. And thanks again to the committee for your work on that. Asking kids a lot of questions that they answer about how they're doing, how they're feeling, where they get help, if they feel safe. And the most recent report, which includes a 10-year analysis, is nothing short of a 5-alarm fire. And I know it's not new to any of you, and it's not new to me, and it's probably not new to anybody in this room or watching, but some of the numbers on page 4 that we included here. This is a quote from the CDC report. Mental health among students overall continues to worsen, with more than 40% of high school students feeling so sad or hopeless that they could not engage in regular activities for at least 2 weeks during the previous year. That's a particular question. We saw an increase in the percentage of youth who seriously considered suicide. In 2021, almost 60% of female students experienced persistent feelings of sadness, and nearly 25% made a suicide plan. This is a survey of over 17,000 high school students who are reporting anonymously what they think and feel that maybe they have no one else in their lives to look at. One thing I didn't see quickly in the report that the CDC usually reports on is the percentage of kids who answer yes to that question about sadness or hopelessness. How many also answer yes to the question of, do I have someone to talk to? What I can tell you is the 8-year analysis prior to this report showed that the number of kids who answer yes to the question of, I had someone to talk to, has gone down precipitously over the last 8 years. And what the CDC is telling us is our problem is getting worse. For the first time, they're analyzing protective factors for youth, which include connections at school.
Sarah, this is your
connectedness.
3-minute warning, just so you're aware.
Thank you. So there's more to say. Did include the Connecticut suicide data on the next couple of pages. And just in the last month, we've had 2 likely suicides of young children, 12 and 13 years old. In the state of Connecticut. So this is a trend we're seeing here as well around the country, where the age of children dying by suicide continues to get younger and younger. I have stuff on everything here, so I'll just stop and appreciate your raising all of these bills. And that's why my testimony is so long, but I can go through it with you and answer any questions that you may have.
Thank you so much. As always, those numbers, I think it's no secret to everyone who's here. who's been on this committee or worked with this committee over the past few years, that there is an absolute personal connection to those numbers for me. So to hear that they're not getting any better is an absolute tragedy in itself that leads to these other tragedies. And while we don't have time here today, because we're kind of jumping off of nothing when I ask this question, I do ask that perhaps you think about what else we can do. I mean, I remember when I first started here in this committee, based on hearing these things as we've had these open discussions, I went out and I bought question and answer cards, and we used them at my dinner table. And I'm one of those annoying parents now, but it has really opened up that communication. And my kids do tell me everything. Sometimes you don't want to know, but you got to know, right? So, we create programs here that help parents to do that. So, and this is posed to you and to everyone in earshot and eyeshot. If there are any ideas on anything we can do, we want to hear it. Absolutely. But let's talk about the Title IX toolkit. I do have some questions regarding when and how that toolkit would be appropriate. So let's start back with, as members of this committee and the audience and you're very well aware, over the past year or two, we have had a significant rise in the amount of adult sexual misconduct in schools. And consistently, please correct me if I'm wrong, but consistently you've found that these instances happened or went on longer because of a lack of understanding of what? Title IX itself, of what these things that we're always talking about in this committee look like, the grooming, the signs of abuse, all of that. Can you encapsulate kind of what you attribute that uptake to?
Yeah, I appreciate the question. It's hard to know if there's an uptick, right? Because it's all about what gets reported. And so just something I want to draw your attention to in our testimony, we cite some of the federal work that has been done. And in 2014, the U.S. Government Accountability Office, the GAO, put out they get asked by Congress, what do they want to review? And they put out a report citing research showing that 9% of surveyed students, those were 8th graders through 11th graders, were disclosed that they had been victims of unwanted sexual contact from an adult in their school career, most often a teacher or a coach, right? But that these are so often not reported by kids, right? They may tell each other, they're not telling mostly their parents, it's not getting reported. The GAO report found that states and local school districts need more help and guidance to comply with their obligations under federal law. The U.S. Department of Education in 2017 then issued a comprehensive and frankly very good technical assistance guide for state education authorities and local school districts about adult sexual misconduct in schools. And what they talk about in there and what they talk about in the GAO report and what we've seen in our investigations is it's not one thing, right? So when something gets reported, so there's a lot of news in the last several months about something in Plymouth, Connecticut that happened, right? Some folks may have seen, and they're the teacher who was alleged to have done things, he shouldn't be doing with children. And then people come out like, I knew about that guy. I told people about him. Nobody listened to me. Parents were always uncomfortable, right? And then all of a sudden you see the sort of rolling of administrative heads, right, about it. And then these reporters tend to focus on why didn't anybody report the mandated reporting? Many people didn't report what they saw. And that's certainly a piece of it. But my perspective when I talk to policymakers and reporters about it is nobody goes to school as a teacher and administrator for the most part, right? And thinks, I don't want to do right by my kids today. I'm going to look askance at wrongdoing. So when that happens, it's really about how are we empowering, supporting, training folks who work with, supervise, administer programs to know what they're looking for, know how to respond to rumor, to innuendo, right? The GAO specifically talked about this phenomenon of cognitive dissonance that occurs when, we all sort of know, boy, this happens, but nobody ever believes it happens where they are. And that the part of the response to that has to be that training for teachers, administrators, et cetera, has to specifically talk about the prevalence data to sort of address that cognitive dissonance, because what we know is it can and it does happen where children are, right? That's why all the things your committee works on around background checking and standards for camps and it matters, because things that happen to children happen in the places that children are, right? So the answer to your question is, I think and why I think this group that came together in 2016 to do the sexual abuse curriculum should come back together to say, look, what else do we need in the toolkit? What do we need to have? Well, we know we need training. It's got to be good training, though. Not like 2 days of administered training that doesn't really talk about any of this stuff, which is sometimes still what happens. It's got to be good training. It's got to be thinking about who's most vulnerable in the school system, kids with disabilities, kids, LGBTQ children. Got to be thinking about who has the most contact with kids in schools, and how do we make sure we have appropriate parameters and policies around that. Got to be thinking about what are our model policies for, how youth and staff engage with each other electronically or on social media or after school. The USDE Technical Assistance Toolkit, which could be in part adopted, by the state, addresses a lot of those things, right? So, we have a framework for doing it in law, bringing this group together. I think districts have told us they need the help. We certainly see evidence of that in our reviews, and this is a pathway, I think, to doing that.
Yeah, fantastic. Thank you. And, we talk a lot about adult sexual misconduct, but does Title IX also cover student to student sexual harassment?
Yeah, so Title IX has broad protections against harassment on the basis of gender identity. That's going to cover a wide range of behaviors that make children or covers adults, so it'd be adult concerns. And so yes, is the answer to that.
So let me ask you this, if we're going to create a scenario where there was some possible stalking, some sexual harassment between one student to another, that student made a coach aware, and the coach therefore said, well, maybe we'll deal with it after the season ends. Is that a Title IX violation?
Yeah, it would be. And so, and I'm closing my eyes because I feel like I'm in a law school exam here. Okay. But I'm thinking, want to get it right. I didn't bring any pencils up. No, it's an excellent question. And because every adult in that system has an obligation to know what their role and responsibility is, right? And what the law requires is that districts have Title IX coordinators, and everybody should know who that person is, right? Students should know who that person is, right? And then, any adult, just like with mandated reporting, right? If the coach heard about that a child might be, well, you got to deal with it right then. It's got to be dealt with promptly. It's got to go through the Title IX process. That's one of the things we often see, right? Is that districts may do something, but they're not going through the Title IX process. They're not using their coordinators.
And that is federal law to
Yeah,
do
it's
that.
federal law to do that, right?
Mhm.
And to make sure that there's a process that kids and other adults and parents know where to make a complaint. So you got to know, then the complaint has to be recorded. The youth has to be responded to while the matter is pending. Services have to be offered, to the alleged victim, right? To make sure they're not, might not be coming to class. They might be not coming to their sporting event, right? Because of their discomfort, because of something that's happened. So there's lots of guidance from the Federal Office for Civil Rights about how Title IX entities, which include schools, need to respond to these types of complaints. And, I think I don't think it happens.
Do you have any concerns that under federal legislation, the Title IX coordinator role isn't maybe taken seriously enough, given enough guidance, or visible enough within the school system?
I think the answer to that is from what we've seen is yes. Right. I'll give you just a quick example. We actually have a couple of these types of mini investigations going on right now, right? Where parent came to us with, this is something that happened in my child. One of the cases, the adult was arrested and charged, substantiated by the Department of Children and Families. And So we did a quick, what we called sort of Title IX review. And what that means is we went back to the district and we said, asked them a couple of, what we find to be key questions. Can you give us a list of all the Title IX complaints that have been made that you've investigated in the last 5 years, right? Who the Title IX coordinator is and what trainings you offer to administrators, staff, and students around Title IX and specifically around adult sexual misconduct and grooming. Like that's it. Then you give that to us, right? And so some districts will say, we've got 1 in 5 years, none in 5 years, right? So here's our coordinator, right? Here's our training, but that tells us, those questions tell us that they don't have a working comprehensive plan for understanding what their obligations are and responding to them. We might then compare those answers to what we see in the DCF database. How many times in that school district has something been reported that implicates a Title IX responsibility, right? Student on student, adult on student. Blah, blah,
So
blah.
there could be DCF and a Title IX issue and those two things, but it's only reported on the DCF side, not on the Title IX side, right?
Correct.
So under federal Title IX, if these things go uninvestigated, is there a civil action that can be taken? And is it against the school, the person? You know, can you sue if they don't do it?
So now we're starting to veer into not my area of expertise, but I believe the answer to that is yes. It has been yes. I know one Connecticut school district not terribly long ago was sued and over these kind of issues and had to pay out I believe a multi-million-dollar
It's
settlement.
right. So this is what I want to get at, right? So
gonna be
districts, because I have to admit to you that I knew the answer to that. And I asked you anyways, yes, you can sue for Title IX violations. And yes, they do, they pay out, they're big payouts. So if this requires any extra time, energy, or what have you on behalf of school districts, it's ultimately for their protection, correct? Because it would be less expensive to train people than to pay a multi-million-dollar payout. And essentially these, the numbers show that there are these problems all across Connecticut without actually doing the work that's supposed to accompany them, correct?
That is certainly our belief, right? And this committee last year passed a bill requiring that the CDC Youth Risk Behavior Survey that's implemented in Connecticut add, and that process is well underway, questions about adult sexual misconduct.
So important.
It really is important because what that's going to begin to give us is some more baseline state-based data around what kids feel that they can self-report in that anonymous survey. So that's going to give us, once that's fully up and running, probably for the next survey, we'll start to get that data in Connecticut and can track it over time.
You know, and anecdotally speaking, you know, when we were first putting together those bills, on adult sexual misconduct starting in, I believe it was 2018, we began with this. And I was at a child's birthday party and I was working on the bills and someone asked me what I was working on. And all the moms gathered around and at least 6 of them told me stories of what happened when they were in school.
Sure.
So it's nothing new.
No.
Right. And we now know better. And when we know better, we're expected to do better. And this bill will essentially help districts do better. And I just want to reiterate and see if you agree that any particular time or money cost that would be associated for school districts would ultimately be far, far less than the amount they could possibly be sued for if they're in a Title IX violation.
Right. And you have to comply with federal law.
You
And
have to
that's
comply
not-
with federal law.
Right. You
Right.
have to do it.
Okay. Thank you. That concludes my questions. Are there any questions from members of the committee? No? Well, you were so thorough.
Can I say one more quick thing?
Always.
Thank you. I didn't address, because I thought you'd ask me, about the visitation bill. So I just wanted to underscore that, that is something we got to, I think that's something that's got to be clarified. So I want to, there is no data right now on how often visits are virtual or not. Our fact finding around this suggests that virtual visits do still occur. They typically happen at the discretion of supervisors and case reviewers at the DCF area offices. And as DCF testified to today, there is no substitute for an in-person assessment of how a child is doing. There are also other obligations in state law that may require meeting with a child one-on-one, particularly where an adult is the alleged perpetrator. And it's unclear how that could be done in a virtual framework. So I just wanted to say, I think it is really important. We made some suggestions in our written testimony and provided some options that we
Great.
think would be important. But I do think something might need to be done about it this session.
Do you, and again, this might be out of your scope of practice. Do you know if there are any legal concerns with, if a family says someone here is sick with COVID, that that DCF could require a positive test to be shown?
So first I want to say, I don't know sitting here that that's the only way a virtual visit would occur right now. So I do think that this is worth some more fact finding from the OCA and from DCF to, particularly without quality controls in place right now. Like, so right now, some of the providers share with me, they have to record whether they're doing a virtual engagement or an in-person engagement with their client, with the family. It doesn't sound like that's in place right now at DCF. So without a clear quality control framework for whether visits are done virtually or not, and given the pending bill, I think we need to do a little bit more fact finding around that to establish what some of the practices are right now. To your question, I usually would say that, absent absent authority in state law, a state agency like DCF can't make anybody do anything absent a court order. So that's the law, the legal answer. In practicality, when a state agency is knocking on your door and is telling you something, you may feel that power imbalance and feel you have to do, right? Or not, right? But there's no legal, DCF can't make you produce that without a court order to that effect.
Okay, thank you. And, we discussed with the department here today, the concern about a family who has an open case and has pulled a child out of school for the purpose of homeschooling while also having an open case. I think Representative Lanu was concerned that this is somehow holding homeschoolers to a different standard. And I want to be very clear that we're not talking about all homeschoolers getting a knock on the door from DCF and having a home visit. This is really about if they're already in the system, they've been pulled out of school and are now homeschooling while there's already something in the system about abuse and neglect. The way that the language is written now, it does allow for homeschooling. Given that you have done some research on this and wrote a report, would it make this legislation stronger and contribute to the safety of children if we were to remove the homeschool part?
I'm just trying to think that through for a second. So I also want to clarify on the, it's a tough issue to talk about, right? Because when we were, and that was the Matthew Tirado report we talked about, it was actually five years ago that I know.
We've been together that long.
Long time. The issue, and in that case, the case was open. Matthew and his sister's case was open with DCF and the juvenile court. Matthew's mother was not letting DCF come in to see the children. And during the course of the open case, their mother withdrew the younger child for the stated purpose of homeschooling. And then ultimately, she remained non-cooperative with home visits. The case was closed because of her lack of cooperation. And Matthew subsequently died by homicide from child abuse. And he also was not attending school, though he was enrolled. And that's what sparked, I revisit that only to say why we then looked at, what are the numbers around kids who are enrolled and then withdrawn? And does that happen in other cases where DCF has a case? And the homeschooling piece is unfortunate because it's not, and this I think goes to Representative Lanou's point, it's really not about homeschooling at all. It's about using that as a subterfuge to permanently withdraw your child where other folks have raised concerns about their being abused or neglected, because Matthew and his sister weren't homeschooled at all. Right. So it's not about homeschooling. It's about whether, given the absence of sort of any framework around that in Connecticut, a lot of states have lots of framework around that. Connecticut isn't one of them. Are there concerns that there are some individuals who use the pretense of homeschooling to then withdraw their children from the view of mandated reporters? I think the answer to that question, in my view, is yes. As to the statute, the proposed bill, if it were, I don't know that, I know why that language is there. I might write that, we put that in our testimony today. First, I think all visits should be in person. To the extent that we're looking to clarify times when it must be in person, I would say investigations, any nonverbal or non-school age child or non-school enrolled child, you could say, right? And that's where we're not singling out, we're really talking about it'd be anybody, so if I have a 2-year-old, right, who's not enrolled,
But not enrolled still wouldn't capture those children who were enrolled and taken out because they were somehow questioned as to whether or not their child was abused or neglected. So I'm not sure that solves it. And we may not come to an answer here today, but at least we've actually identified the problem.
Yeah.
And we'll continue to work on
Right,
that.
the language.
But one thing that you had said was you think that more research is necessary as to what's currently in practice. My concern is how long would that actually take? Okay, because I don't want to wait another year to do this legislation. So if we can get that would be great. And if not, then we just add that and have it happen according to the legislation. So I think that there are different ways that we can attack this issue. But I guess my final question is, do you believe that it's extremely important that we enact this now?
Yeah, so that's where, and I meant sort of like the best fact finding we could do in the moment to help inform the solution. Okay, not like a study of, I get it. I get that. No, I think it's really important, right? Because then that part of what we're pointing out in our testimony is there are requirements around visitation in statute. But in a post-COVID-19 world, I don't know that it's automatically clear that that means in person, right?
Right.
And so I think we have to, we gave you in our testimony some of the other statutory references to visitation requirements in DCF cases just to have. I think it's really important. I do think it's important to do something and clarify in state law and agency policy what the expectation is around visitation in a post-COVID-19 work environment.
Okay, perfect. Thank you very much. Are there any other questions? Absolutely. Please, Representative.
Thank you so much. Quick question. You said in the beginning, as far as the toolkit, when you talked about the surveys of students, you said 9%. Do you remember the grade range?
8th grade through 11th grade.
8th grade through 11th grade. All right, thank you. Because it just brings me back to the topic. We're all here for one reason, of course, the children. So now that I think about it, the toolkit being very, very important, just understanding, you talked about the training process and stating that, okay, it shouldn't even be like a 2-day thing. It should be more than that. And, Madam Chair spoke about it being federal law. And then now we go back to the chain reaction of to youth being tragic. You know, so I definitely think that it all intertwines in one thing. So I definitely appreciate you for testifying, but most importantly, I appreciate, you know, the toolkit in general. Thank you.
Thank you, Representative. I appreciate that a lot. Any other questions? Seeing none, thank you very much.
Thank you.
Yes, next we have, please, Christopher Davis, followed by Commissioner Bai. Hello,
Good afternoon.
please contain yourself from telling us how much you miss being here.
I certainly do miss being here. And although in my time in the legislature, I never had the honor of serving on the Children's Committee, I always enjoyed working with members of the Children's Committee on a number of issues, especially yourself.
But you
Madam
saved
Chair.
yourself from a broken heart. As you can see, the things we talk about are quite heavy, but
Quite
thank you.
tragic,
Please
yes.
go ahead.
So thank you very much for having me here today. I am Christopher Davis. I'm the Government Relations and Responsible Gaming Manager for the Connecticut Lottery Corporation, and I'm here to testify on House Bill 6641, an act requiring proof of age for purchase of lottery tickets. And I do want to thank the committee for bringing up this issue. It's one that we at the lottery take very seriously. So responsible gaming is an embedded core value of the Connecticut Lottery Corporation, and it is our charge to address problem in underage gambling by taking proactive measures to implement and support responsible gaming initiatives. Demonstrating CLC's ability to meet these high standards in our industry for responsible gambling, CLC was one of the first lotteries in all of North America just 2 years ago to achieve the highest level of responsible gambling standards verification from the North American Association of State and Provincial Lotteries, as well as the National Council on Problem Gambling. Per state statute, the CLC currently provides $3.3 million a year to the state's chronic gamblers rehabilitation treatment account. And this money is used to fund all of the treatment programs for problem gambling for the state of Connecticut, including youth prevention programs, as well as the state's problem gambling helpline. So in furtherance of this commitment to preventing youth gambling, the CLC also was recognized last year by the National Council on Problem Gambling with their 2002 Gift Responsibly Campaign Award for our annual Give a Child a Toy, Not a Ticket campaign that you may be aware of, where we spread the message that it's important to not give lottery tickets to children for gifts. And we are able to raise over 30,000 toys for the Connecticut Children's Hospital through that toy drive across the state as well. So we're very proud of that initiative. So under current law, no person shall sell a lottery ticket to a minor, and no minor shall purchase a lottery ticket. And anybody who violates this, whether they're the purchaser or the one who sells it, is they could be subject to a Class A misdemeanor, which is actually the highest level of misdemeanor that our criminal code has. Currently, the Department of Consumer Protection monitors our lottery sales agents to ensure that they are in compliance with this law. If someone contacts the CLC to inform us that they have an idea that somebody might be selling to minors, we immediately contact the Department of Consumer Protection, and we launch a joint investigation with our own security investigators, as well as with the Department of Consumer Protection. And DCP actually has special policemen that are authorized to investigate and arrest anyone associated with offenses related to the conduct of lottery, including the sale to minors. Additionally, per our lottery sales agent contract, we will terminate it if somebody is found to have sold to minors. And DCP has the ability to revoke or suspend their license doing the same. So House Bill 6641 proposes that lottery sales agents must require all purchasers to provide proof that they are 18 years of age. And though we appreciate this effort to further prevent sales to minors, it's probably not necessary to require all purchasers of lottery tickets to have to show an identification. And to that end, we are recommending language to change one word in the bill. And the word was shall to may, which, as you guys know, in legislature is it's sometimes a big change. I see Commissioner Bai over there. But I don't think it is as much of a major change in this particular case, but one that could be beneficial that avoids unintended consequences. In changing the word shall to may, you're actually empowering the lottery sales agent to require the purchaser to provide identification if requested, while also preventing unnecessary delays and some of those unintended consequences to all patrons in any of these establishments who may be caused when a lottery patron, no matter their age, is required to show the ID. And I
Thank you.
see that
your
that's my
3-minute warning.
time, right? Little experience. giving
Wow,
testimony,
you
right?
timed that beautifully. Okay, so a few questions.
Sure.
I know that there are some retailers that say we ID under 30, right? So if we, I don't think that that's actually though in statute, correct?
Correct. That is not in statute. Currently, the statute states that you shall not sell it to a minor. And
But what about for alcohol? Are you aware of this? You might not be since it's not where you are.
I am
but-
not aware.
Yeah, because I just don't know if yeah, he's saying no. So, we were discussing this as the bill was being put together. I was like, okay, is there already a statutory reference to IDing if someone looks under the age of 30? But it's hard to do that when it really comes down to someone who's really trying to be very nice to me might think that I need to be carded. So I think that that's not something we can put into statute. So
Sure.
we were kind of wondering exactly what to say, but I mean, you've been here a while.
Mhm.
If we change it to May, is it going to make a difference?
So by changing it to May, where you do have a change in the statute is that it would still require the patron to have to show the ID. Currently, right now, I suppose someone could ask for an ID and that patron can say, no, I don't have it. It's in my car. Sorry, I don't, where is it? And then they wouldn't be able to, or they might still consummate the sale, right? But by changing it from shall to may, you do set up a scenario where it would be on the patron that be required to show their identification if requested by that lottery sales agent. So there is still a change that is possible by doing that. If you leave it as shall, one of those unintended consequences potentially could be
You sell less
equating,
tickets.
well,
You know,
but I think what the unintended consequence could be too for the lottery retailer perhaps is that you're equating a sale to say someone who is 75 years old, purchases a ticket, doesn't get carded. DCP happens to be there on one of their monitoring missions, sees this. Now it's in statute that it's the same thing to sell to that 75-year-old and not ask them for the ID
Yeah.
as it is to sell it to that 14-year-old and who's under the age of 18, right? So that's an unintended consequence that I don't think was necessarily your intent at all, but could happen if you leave that word shall in the bill.
so then do you see that this is somehow a problem?
So right now, and when this bill was proposed, I did reach out to our director of security, who would be the person who heads up these investigations. And he's been there for a few years. I think he said 4 or 5 years. And in that time, to his recollection, we've received about 4 or 5 complaints over that time of someone potentially selling to minors. Each time we immediately contacted DCP, an investigation was launched, and each time it was found to be unsubstantiated. Perhaps the person just looked young and someone just called in and they were able to verify that the person wasn't, or something along those lines. So as far as an issue across the state, it doesn't appear to be a major one whatsoever, but I do certainly understand the concern of individuals being able to access this product.
Then I'm just trying to find out why the bill had come to us. If you don't think it's a problem, is there just some concern about now that there is legalized gambling? While I really don't believe in the whole idea of a gateway drug, but is this kind of the issue that you think that this could perhaps be a gateway?
I find that the online gambling, there's actually very strong know your customer, KYC protocols in there that it would be nearly impossible for somebody under the age of 18 to perhaps access when we do launch iLottery in a few months, the ability to purchase draw games online or something along those lines. So, I don't see it as an issue currently, and one that actually has those additional built-in protections when you do go into the online space.
All right, great. Thank you very much. We have a question from Representative Kit.
Yes, thank you for being here, and kudos on your Toys Not Tickets campaign.
Thank you.
It's a good thing my grandma Sophie isn't here to hear that, because it would have changed my entire childhood. Christmas just would not have been the same. I have 2 questions. You said that terminations of licensure can happen if you violate regulations. In the past few years, how many licenses have been revoked?
So I asked our compliance manager at the lottery that has that direct report with DCP. Now, to give you a perspective, when DCP goes out and does these kind of site inspections. They don't inform us. We're not aware of it. The retailers are not our employees. They are licensed to sell our product by DCP. So in speaking with my compliance manager, and DCP would be able to give you the exact answer, but in her time at the lottery, they have not revoked one for sales to minors.
Okay. My second question, it may just be more of a comment. Just yesterday, I was at a meeting of the Trumbull Prevention Coalition, and they brought up gambling as a problem and stated that, in fact, these lottery tickets are usually a sign in the beginning. They basically, it's a sort of a gateway drug. They did say that, and that they have evidence that says that it leads to more and progressive gambling habits. So I would be hesitant to relax the language. And that's just my comment.
If I may. Yeah, to that. So in addition to my role as responsible our government relations manager, I'm also the responsible gaming manager for the lottery. So I also, work on this on a daily basis. And what you oftentimes see is that access to these lottery tickets, as we just discussed, is not necessarily from someone walking into a store and buying it, but it's from receiving it as a gift, receiving it from someone or having someone buy them for you. The language that's in this bill right now wouldn't prevent any of those situations from happening, right? If somebody over the age of 18 were to walk in and purchase these tickets, this language wouldn't prevent them from then turning around and giving them to a younger person, which, as through our campaigns, we try to tell you not to do. And so, that would be to that response to that concern. I work very closely with CCPG, the Connecticut Council on Problem Gambling. You probably will hear from them, I think, a little bit later on here today, and the Department of Mental Health and Addiction Services. In fact, I was in contact with them this morning about our Problem Gambling Awareness Month program for next month. So, this is a topic that we do take very, very seriously, and one that, we want to see avoided at all as much as possible.
Thank you. Thank you, Representative. Are there any other questions? Nope. Seeing none. Thanks.
Thank
It's
you.
nice to have you back for a minute.
Thank you.
We're going to have, please, next Commissioner Bai, followed by Joshua Dammel, and then Representative Rader.
Good afternoon. I'm happy to be here. Good morning, Senator Marr, Representative Linehan, Senator Seminara, Representative Dalfinis, and distinguished members of the Children's Committee. My name is Beth Bai. I'm the Commissioner of the Office of Early Childhood. I'm here to testify about House Bill 6644, an act concerning the distribution of information regarding special education services to families and children. I'm not going to read my testimony. I'm going to sort of explain to you our point of view. First of all, much of this legislation simply codifies practices that are already in place. So for the most part, that's fine with us at OEC. Transition planning is very important when families are moving from birth to 3 into the public school system. I want to spend my time focusing on the part of the bill that OEC does not support, even though, as a former early childhood educator who sat in many a PPT, I completely appreciate the intent. So the following language is what we have trouble with. In paragraph, in parentheses number 2, we don't support the language that says review the individualized family service plan for such child with such persons responsible for the administration and coordination of special education services.
Excuse me, Commissioner, can you give us a line number? Do you have a line version?
I do not, but I have with me Ashley McAuliffe and Nicole Cosette from our Birth to 3 program. Can you pull that up?
I apologize. I
Nope,
just want to follow
that's
along
fine.
with you.
I understand. I just have it in the parens too. So we'll get that for you.
Because there's many 2s. Can you point to the section?
She's very close.
Line 76. We will all follow along. Thank you. Go ahead.
Sure. So in that subsection 2, as I was reading, we have concerns with this language because federal free appropriate public education or FAPE at age 3 requires that school districts provide appropriate support for children at age 3. The way this reads now, and there may be ways to fix that, is the wording suggests that the service coordinator would be the one to determine if the district has the resources appropriate to support the child. I think the approach of Part C is always, we work with the families, and when they're in the IFSB meetings, Birth to 3 works with families to get the supports they need. As they transition into the public schools, into the IEP process, Birth to 3 really spends their time helping parents advocate for their child. They are not the ones who set that. So Part C values supporting the transition process, and that's the service coordinator's role, but they don't determine the eligibility and supports within the Part B special education services. Under IDEA, with parent permission, the service coordinator is available to support the competence and the parent's ability to describe their child's ability and challenges, and provide strategies to support their learning. At the planning and placement team meeting, it is not the role of the service coordinator to make recommendations on issues such as special education goals, personnel placement, or services. And I just close by saying, having been in these meetings, I totally understand where it's coming from, because the child, you want to make recommendations, but that's just not the role. The role of Birth to 3 is to support the parents, to ask for those services, because those skills that Birth to 3 staff are teaching parents stay with those parents throughout the rest of their education and the PPT process. So I'm happy to take questions. I hope that was helpful.
Thank you. It was helpful in that I have to figure out how to work with my co-chair to fix it with you.
Mm-hmm.
But it was not helpful in that I suddenly have an answer on that. So I think then on behalf of my co-chair and myself, I will just ask, will you please make yourself available so we can have a meeting and go over it?
Absolutely.
That's really the only question I have on that.
I'll bring my hotshot staff too, because they're
Excellent.
and our legal counsel perhaps can help. But
yeah, please,
I
whomever
totally get the intent, and I have lived that frustration as an advocate for children in those meetings. So I understand where it's coming from, but I think as commissioner, rather than an advocate, I have to look at this at a systems level.
Sure.
And our job is to try to figure out how to help the public school system and the Birth to 3 system work better together in that transition process.
Well, we really appreciate your expertise. And I think I can actually speak for the committee when I say that we're just thrilled that you're in this role, because you have played multiple roles within this, including obviously state senator. And so you come to this with a wealth of information that others may not. And so your guidance is appreciated and trusted. So I look forward to having us sit down and talk about that.
Sure. And I think we should do it with SDE, because I think they too, have these concerns and also want to get it right. So
Yeah,
we're happy to
fantastic.
do that.
Sounds good to us. Do you have any questions? Any questions from members of the committee online? Or
Great. Well, great to be here. Thank you. for
another
having
one
me.
of those times where you're so succinct and you got it down, and you
I know
answer
what
all
it
the
is to be sitting
questions.
there and ready for your lunch.
Appreciate you. Thank you so much. And to your hotshot staff.
Hello, my name is Joshua Dommel. I am a legislative intern with Representative Kate Farrar of the 20th District. I will be delivering testimony on behalf of Representative Farrar today. Unfortunately, she is unable to make it and she sends her regards. I also want to give a quick thank you to Sarah Egan for her very thorough testimony on the bill that I am also presenting testimony on today. I am presenting testimony on House Bill 6642, an act concerning Title IX compliance toolkit for school districts. I want to thank Committee Chair Senator Mayer and Representative Linehan, Vice Chairs Senator Kushner and Representative Kitt, Ranking Members Senator Seminara and Representative DeFenis and distinguished members of the Children's Committee. I am here today to testify in support of House Bill 6642. Just last year in 2021, our country celebrated 50 years since the historic passing of the Federal Civil Rights Law Title IX, which prohibits sex discrimination in schools that receive federal funding. A lot has changed over the past 50 years that we've seen here in our country, but there's still much work to do to advance gender equity in education. The Title IX at 50 report produced by the National Coalition of Women and Girls in Education highlights several core issues where Title IX is falling short for our students. First, sexual harassment, sexual assault, dating violence, domestic violence, and stalking are all prevalent in schools, but very few students report it, as we heard before. Especially in grades 7 to 12, 56% of girls and 40% of boys are sexually harassed in a given school year. And 1 in 5 girls aged 14 to 18 have been kissed or touched without their consent. These numbers are astonishing and frankly send a chill down my spine. But as we all know, these numbers are only compounded through many intersectional aspects of oppression, especially individuals in the LGBTQ+ community who face harassment and assault based on their sexual orientation, gender identity, or gender expression, particularly transgendered students who face a particular risk in this regard. In 2019, more than 8 in 10 LGBTQ+ students were verbally harassed, and over 1/3 were physically harassed. Plus, Black girls, girls of color, and LGBTQ+ children are more likely than their peers to be more severely disciplined or pushed out of school due to race and sex-based stereotypes. Also, women in schools have fewer opportunities than boys to play sports. And when they do have the chance to play, girls are often the recipients of worse facilities, uniforms, equipment, less experienced coaches, and less publicity from their schools itself. Finally, sex discrimination continues to hinders girls' participation in STEM and career education throughout high school. The gender gap in the STEM workforce cannot be blamed on the differences in academic participation, and the biases and stereotypes begin at a very young age between men and women, especially growing up through school. Pregnant and parenting students also may face institutional barriers, including school attendance policies, lack of childcare, transportation, and care for their young children, and even outright discrimination in a lot of cases. Given the
Josh,
scope,
that is 3 minutes. If you could please summarize.
thank you. Given the scope and scale of Title IX, Rep. Farrar would want to suggest a few changes to the drafted bill. First, concerning the makeup of this working group that is being considered, please consider adding individuals who can provide expertise on the aspects of, especially of K through 12 sports, STEM education, and student parents, as well as adding language to the bill that addresses all aspects of Title IX protections in the toolkit. Rep. Farrar hopes that this toolkit is the first step to a recommitment to Title IX following its 50th anniversary. It's an ideal that that Rep. Farrar believes should be embodied in all aspects going forward. Thank you.
Thank you so much. That was absolutely fantastic. And I know that you are testifying on behalf of Representative Farrar, but I'd like to ask you a few questions based on your experience, if you don't mind.
Yes, of course.
Great,
And
thank
any
you.
questions directed at Rep. Farrar, I would be happy to take as well. I can get those to her and make sure she gets back to you in a time.
That's awesome. Thank you. The committee is the Committee on Children, and for years we have really tried to encourage kids to come and testify. And I know that you are beyond that, but your experience is more recent than mine, to say the least. So I agree with Rep. Farrar. You know, this legislation that we're looking at right now really came about because of adult sexual misconduct. It's something that the committee has been focused on for years. And there frankly still a lot more work to do, but you're right. The representative is right. There's a lot more to Title IX than that. And we believe that that could ultimately be represented even as passed out of committee such as this. But I will support Representative Farrar in agreeing that actually spelling that out would help to recommit to the benefits of Title IX legislation and ensure people follow it. So while not putting that explicitly and outlining it in the bill, it may seem like an oversight. It was really just that it was understood. But I hear that, and will advocate for that change. But I want to ask you, given your time in school, middle school, high school, college, were there ever any times that you have witnessed bullying, harassment, adult sexual misconduct, or any of that harassment that is covered under Title IX, whether it be student to student or adult to student? Have you witnessed any of that?
Oh, absolutely. I think that it is a very, very serious problem that needs more thorough addressing. A lot of what Sarah Egan was also talking about is the lack of reporting. That you see these things that students to students tell each other and that get passed around the rumor mill, but don't get reported and therefore don't get the proper function of what Title IX is all about, and going through the proper procedures. With that, a lot of it just becomes hearsay going through the rumor mill. But absolutely, personally, I know I've seen a lot of that firsthand, and trying to do the best that I can to report and to support in any facets I can. But I know that there are multiple situations that I wasn't a part of that I just know about that didn't get reported, which is really important.
I'm going to put you on the spot. Can you, if you can't, I understand, don't feel pressured, but can you paint for me what an experience is like for an LGBTQ child who experiences bullying based on their sexual orientation?
Oh yeah. I have, I've grown up in a very supportive household, and have many friends and peers who I've seen the experience firsthand from. A lot of it comes from just an ignorance from the adult perspective. A lot of these conversations have just been opened up, especially for trans youth in the past few years. So a lot of administration, a lot of staff don't really know the proper avenues to go about supporting a lot of LGBTQ youth specific issues. And so funding for more training, a part of that obviously going into this Title IX toolkit could really benefit a lot of these LGBTQ youth specifically, who don't have a lot of their issues represented in the sometimes nebulous definition of bullying that gets tossed around. Instead of, a lot of it is also institutional bias that can really negatively affect them, and a lot of it can look different than the stereotypical idea that we have in mind when we think of bullying.
Would you say that bullying towards LGBTQ students, it was prevalent when you were in school?
Absolutely.
Have you ever witnessed it being verbal, physical, or both?
Definitely in my personal experience, a lot of it was verbal, a lot of it was insensitive jokes, and especially making fun of identities and the very concepts of sort of LGBTQ, especially support and help within them. I know that I personally had faced a lot of hardship for just being an ally in trying to support my friends and my peers in that aspect. So definitely I know that my especially high school experience is a few years out, but when I was in high school, that was a very large aspect.
Of those kids that you have witnessed this verbal abuse, because let's call it what it is, it's verbal abuse, of those LGBTQ children or even children of color that you witnessed, because remember everybody, Title IX gives protections to protected classes within the school system, right? So that everyone can get an equal education. So have you ever witnessed someone being verbally abused as a member of a protective class, who then was someone had told a staff member, a teacher, an administrator, and they felt that nothing was done?
Absolutely. That was a big problem. There was some specific larger cases in my later high school years that really struggled with that. Going back to what I was talking about, a lot of administration doesn't have the knowledge or training to really understand LGBTQ specific issues. And so because all of these conversations are, in the grand scheme of things, very fairly recent. And so a lot of that is a lack of knowledge of the proper procedures to go down and the proper avenues to take into actually complying with these protected classes.
And then I'm just gonna give one last question, which again, you might not have the answer to, but let's try. Do you feel, based on your proximity to LGBTQ kids and kids from LGBTQ families, as an ally and an active ally, that if non-traditional family makeups, 2 moms, 2 dads, if when filling out, say, forms or something, if they're not represented on those forms, do you believe that lack of representation would possibly make a child feel less comfortable in school if their family unit was not represented on those school forms that are given out all the time, or communications? Do you understand what I'm saying? Where
Yes,
yeah,
absolutely. Representation is a huge issue. A lot of it is redefined. There's been a very heteronormative idea of what normal is and what a normal family is. The nuclear family, a mom, a dad, 2 kids, and a dog, and a white picket fence. But that is really not representative of how a large proportion of families actually are and operate. I know I personally come from a family where my grandmother took a large position in guardianship and in raising me, and so I know that there is a lot of non-traditional families, and having that representation is so important to create an environment where these youth, especially youth from LGBTQ plus families, feel included and actually are able to be a part of that community, rather than watching a different community with a different set of values and a different set of ideas of what a family should be.
right. Because under the law, they're still a family.
Yeah,
And so if we're talking about following federal law,
absolutely.
then the representation should be there as well.
Definitely.
Thank you very much. You did a
you.
fantastic job. Let me see if there are any other questions. Representative Kit.
Yes, hi. You did a great job. I want to thank you particularly for highlighting the experiences of our LGBTQIA youth and our youth of color who are experiencing discrimination in school, and how they are in fact covered by Title IX. I know a lot of people, maybe from my generation, see Title IX in terms of equity in sports. And it's important that both adults and our children know that Title IX covers much more than just sports equity. And it comes down to receiving an equitable education in a safe environment. So I applaud you for being an advocate. I expect to see great things from you in the future. And I think that I just wanted to make that comment. So thank you.
Thank you so much.
Any other questions? Seeing none, you're all set. Thank you so much.
Thank
We
you so
really
much.
appreciate everything that you said.
Thank you.
Next, we have Representative Rader, followed by Beverly Street Cofalis. I hope that I did not butcher your name, ma'am, but we'll see you soon. Representative Rader, I believe you're with us virtually.
I am. Can you hear me?
We certainly can. Please go ahead.
Thank you. Good afternoon, Chairwoman Lenahan, Chairwoman Marr, Vice Chairs, ranking members, and my esteemed colleagues of the Children's Committee. Thank you for allowing me to be here today and to testify. I am Representative Moira Rader, and I come here today in support of House Bill 6644, an act concerning the distribution of information regarding special education to families and students. I come to you today, yes, as a legislator to advocate for this bill, but also in my capacity as a member of the Guilford Board of Education, and most importantly, as a parent who has navigated the 504 IEP process. This bill is critically important, as it is serving to ensure that the earliest transition our youngest students make into public education is well supported so as to achieve the best possible outcome. Too often, parents or caregivers enter the world of special education with little understanding of their rights, the services available to their child, and the proper process to take to ensure their child's needs are addressed by their new school district. I am thankful to Chairwoman Linehan for seeking my input on this bill in hopes of defining how best to establish a successful transition for our youngest students and their families. Very often, this first transition is very overwhelming for families, and I'm really glad that this bill is hopefully going to move forward. I believe the language in this bill will successfully support families as they enter for the first time the 504 IEP process, giving them the knowledge and self-advocacy tools necessary to seek the best and desired support for their child from their home district. If I could be so humble as to suggest some possible additional language, I would like to suggest the following. Per section 1, paragraph E, item 2, near the lines 79, 80, and 81, I feel the only piece missing that would be important to indicate a remedy should the district not have the resources necessary to support the child needing more extensive special ed services beyond what that district can provide. Meaning it would be helpful to include language whereby the school district notifies the child's family of their determination and provides guidance to the outplacement process, outside resources, and the rights of the child and family to best address their needs. As always, this is only a suggestion. I defer to the committee members and chairs for your expertise and best judgment. It was wonderful to hear from Commissioner Bai and her input. She clearly has a broad expertise in this as well. In conclusion, I fully support House Bill 664 and hope that the language suggested could be considered. And just to leave with this, you know, the navigation of the 504 IEP process can be exhausting, difficult, and overwhelming for a parent. And I just, you know, too often what gets lost in this process is the education of the caregiver. And what's really special about this is being that we are going to be taking caregivers and families in the B to 3 category. It's a great time to serve to educate them on their rights and how to navigate that transition and not to lose any time with that child. And most importantly, if that district cannot service that child, to quickly identify and to educate that family as to their options and their rights. That's it. I conclude with that, and I'm open to any questions.
Thank you very much. I very much appreciate your testimony. I appreciate your work on this. I appreciate you collaborating. And you were on when the commissioner was talking about those lines that you referenced in the bill. So I think that should we get together soon for the meeting, which I hope that we do, my hope is that you would be available as well to sit and talk about that, because you know, it's important. We understand that the commissioner is coming from the government side, but I really think it's important to hear from a personal experience side. And I know that you have that personal experience. So if we're really going to come up with a solution, all sides need to be represented. So I will certainly let you know when we have someone, or rather when we have a time. I want to call your attention though to another part of the bill. That we are very lucky to have an amazing clerk, Emily Zambrello here, who offered some language to go into this bill. I'm very, very proud of this. It's actually one of my favorite parts of the bill. And that is to have a handout, not only for the caregivers, but also for the children who have an IEP and a 504 or a 504 of some kind, to understand what's going on with their education and in their life, and be able to be active participants in understanding what's happening and advocating for themselves. So we did write the language in this that says that there would be an age-appropriate handout. Do you feel that that would be helpful to children as well?
Absolutely. You know, what I witnessed in both many capacities is that very often the child's invited to sit at the table, but they don't understand why they're there. And when they're given the option to participate or speak, they really tend to defer not to. So to really give them something age appropriate, to explain to them why they're sitting with this group of adults, what's happening, what they can expect to reduce that anxiety about the process because it's very anxiety provoking for any child that is going through this process. So I think it'd be wonderful to have something age appropriate because there is nothing right now. It's a lot of language and a lot of big words and a lot of paperwork that especially a young child like that would never be able to understand. And I just feel like you create self-advocacy, excuse me, I can't talk, self-advocacy early. Then they understand that as they travel through and they get older, they are still doing that self-advocacy because unfortunately, too often that piece is not instilled in them early on and they never understand that advocacy right that they have and they sit very quietly in this process and they're the key to this whole process succeeding. So yes, I'm thrilled to hear about this. And I think it'd be really important to make sure it stays part of the bill.
Right, thank you. And it's funny because she brought up this language and I immediately loved it. But I realized that I have been teaching my kids what these things mean. So I've already been doing kind of what was suggested in the bill. And I just want to throw out for the purposes of underscoring the importance. I've been, vocal about the fact that my child had a 504 when he was diagnosed with PANDAS. And we've recently seen a bit of a resurgence, unfortunately, due to a recent strep infection. And my child was able to say, my 504 says I can have a little extra time in this because, one of the things about PANDAS is you have OCD and I find myself making sure that my handwriting is perfect and all these things that go along with OCD, right? But he understood what that meant and was able to self-advocate. And the teacher was like, oh, right, yes. And it just reminded her. And so that brought my kids' anxiety level way down because he knew he was being understood and he had a little extra time and he got everything done. So really, it may sound like a small piece of the bill just for a handout for a child, but I tell that story just because it's tremendously important. So I appreciate you, Representative Radar, for being with us on that. And we will absolutely be in touch regarding a meeting. Are there any other questions from members of the committee? Nope, seeing none. Thank you very much, Representative. We appreciate it.
Welcome. Thank you for all the great work that your committee does. I appreciate it as both a legislator and constituent.
Thank you so much. Next, we have Beverly Street Kafalas, followed by Emily Kendricks.
Good afternoon. I'm Beverly Strite Kafalas. Strite is right, as I try to tell people. I'm the probate court administrator for the state of Connecticut. Senator Marr, Representative Linehan, Senator Seminar, vice chairs, ranking members of the Committee on Children. Thank you for your attention on children, a very important role that you play in our state government. And thank you for the opportunity to testify. I believe this is the first time as a probate court administrator I've actually appeared before the commission, and I've watched the good work of the committee for many years. I'm here this morning or this afternoon to testify in support of two bills. One is Senate Bill 1009, an act concerning identified adoptions. And the second is House Bill number 6640, an act concerning home visits and evaluations by the Commissioner of Children and Families. My written testimony was submitted last evening, so hopefully you'll have an opportunity to see that as well. I really just want to highlight a couple of points about the act concerning identified adoptions. This was a comprehensive collaboration of significant stakeholders, my office, the Department of Children and Families, and child placing agencies licensed by the state of Connecticut. It's an important act, and the language in it is critical for a multitude of reasons. And just to inform and educate, perhaps for those who may not be aware, an identified adoption arises when a prospective adoptive parent or parents identifies a birth parent who intends to give a child in adoption. And these have long been subject to regulations by the Department of Children and Families and are required to be approved by the probate court. The proposed changes to the probate statutes eliminate an obsolete dollar amount and provide that payments or reimbursements to the birth parent are reasonable, limited time and duration, and also serve to meet the pregnant person's living, medical, and legal expenses related to the pregnancy or the adoption. It also provides new language for exigent circumstances where meeting the well-being of the pregnant person and the prospective child may be in jeopardy, to allow for emergent expenses to be paid subject to subsequent probate court approval. What's important as well about the language of this statute or the proposed bill is that we are modernizing the way identified adoptions work, as well as to ensure changes in terminology that are not only inclusive, but also avoid conflict with other statutes relating to parentage, and to provide clarity and conformity with the recently passed Connecticut Parentage Act. I do offer specific technical terminology changes in my written testimony. I would highlight, for example, a pregnant parent should be replaced throughout with pregnant person for a multitude of reasons, as well as the term genetic parents should also be clarified and changed, again, for consistency with inclusiveness, as well as existing state law as codified by the Connecticut Parentage Act. And I would be happy.
Minutes, if you can please summarize.
I'd be happy to work with the committee to address those changes. Just a quick comment about the home visit bill 6640. My support of the bill really is to ensure that if there is a requirement for a specific category of home visits by the department, that the investigations and visits through the probate court proceedings are also included in that statute. I would offer that at this time, there have been no reports to my office that the department is not in fact conducting home visits. That is the standard. Certainly COVID-19 interfered significantly with the ability to have in-home visits and on-site evaluations of children and families. But it is my understanding that is not currently happening, and nor has it happened in some time. I'd be happy to answer any questions. Thank you.
Thank you. So your testimony, your written testimony, will that include including probate, or is that something that you felt you needed to say based on hearing what was happening here today?
No, my written testimony provides a request that the specific Connecticut general statutes that reference the child custody guardianship matters in the probate court system are included in the language of the bill. Specifically, Connecticut General Statutes 45A-603 through 45A-624 should be included in the language of the bill respectfully. And I would suggest that it would be inserted in section 2, which is starting on line 4 through 5.
Great, perfect. And we have all that, and we'll absolutely take that into consideration. I do have a question. It's going to pain me to ask you this, but I'm doing it to stave off the possibility of getting this on the floor. The terms that you agree with and that you believe are very important for this bill, are they so we can be quote unquote woke?
No, they are consistent with federal law. They are also consistent with the Connecticut Parentage Act, which was codified by Public Act 21-15. And it ensures legal clarity for all of the roles that are involved in identified adoption, so that there is no legal problem in ensuring the rights and the protections of the interested parties.
Thank you very much.
You're welcome.
Are there any questions? Yes, Representative Wieslander.
I just wanted to say hi to Judge Beverly. It's been a while and it's really nice to see you. Thank you for coming out today.
Good to see you, Representative Wieslander. I was disappointed when I saw you step out.
I think she came running back for this purpose. So, okay, no other questions? Thank you. And if there are further questions as we move forward, I will certainly ask Representative Wieslander to reach out to you.
Absolutely. Thank you
Great.
very much.
Thank you so much. I did read on the list, oh, no, I'm sorry. We were up to her anyways. Emily Kendricks, please, followed by Julie Hall. Hi, Ms. Kendricks. Welcome to the Committee on Children. Oh, your button is pressed. If you can lean in just so we can hear you a little more. Thank you so much. Go ahead.
Thank you. Hi, my name is Emily Kendricks. I'm 19 and I have been in DCF for 3 years. I'm here in support of Senate Bill 1008. Back when I was 17 and first introduced to my attorney, Stacy, she had reached out to me to get a little more background information on my situation. I had a court date coming up where my parents were going to decide if they were going to give up custody for me or not. She answers the questions I had and explained what the court meeting was going to look like and what outcomes might happen. She made sure that I had a clear understanding of everything that was going on, as well as an understanding of what the outcome I wanted from the situation, and use this information to best decide how we could accomplish my goals. She informed me about the different support funds that DCF had been available to help me in my situation. This was my first time hearing about many of these rights and funds, even though I had been involved in DCF for a while. I could tell that she wanted to help me, and I was thankful to have someone that was introducing me to so many different supports that I could utilize if needed. I volunteered to stay in DCF care past the age of 18, and my attorney volunteered to stay with me. This meant the world to me. It was so reassuring to know that somebody cared about my success so deeply. Having a lawyer has helped me so much, especially during my initial transition to becoming an adult as an 18-year-old and to a 19-year-old. She advocated to ensure that I got the correct healthcare that I needed, advocated with DCF to make sure that I always had transportation to and from school, as well as connected me to people who are showing me how to advocate for myself and others. Nobody else in my support system has been as supportive as my attorney. Stacy is able to raise questions if she noticed something is not going the way that it's supposed to. I have no idea where my life would have turned out if she did not stay as my lawyer and help me learn how to advocate for myself. There's many youth I know in the DCF system that I wish I could give my lawyer to so she could help guide them as much as she did for me. I hope this bill gets passed so every child in DCF feels invested in, make sure that their rights are enforced, and is entitled to equal support systems. Thank you.
That was fantastic. Thank you so much for being here and for advocating for this change. I absolutely love when you guys come in and talk about this because it's really proof that there's a reason why we're doing this bill, right? And so thank you very much. And as you were talking, I was looking for some notes that I had. And so I just want to see, we're talking about, there are some opt-in services pursuant to DCF policy until the age of 23.
Right.
And I don't know if this is a question for you or if it's a question for your lawyer, but though you're in need of other services beyond those that are current opt-in services, and that's why this bill is doing this.
Right.
What specific services do you think are the most helpful that are missing if your attorney didn't volunteer those services that they should be covered under DCF policy anyways?
That's a really good question. I think it's definitely case by case for each youth in DCF. Like I know for myself, health advocacy was like a really big thing that I needed. But I know many of like other youths in DCF where it could have been supports to like housing or supports to housing, getting into school, stuff like that, or other healthcare or like just stuff like that, I guess. It's kind of, I feel like it's definitely more like individual.
So we did have someone here who was also fantastic. I mean, you've got some great clients that came in and talked to us about housing a few years ago. And so we recognized that need. I will be honest with you, I didn't even think of the healthcare advocacy until you spoke here today. That's a really great point. And so being in the system and then aging out, like that's scary, right?
Right, right.
And did you almost feel like you were just like left to fend for yourself?
Right. I think definitely the choice when you turn 18 to stay with DCF or to not stay with DCF is a very big choice that every youth has to make. And like having somebody that knows rights and knows like a little bit more information than you do to help guide you is very like important for everybody, because it is such a big decision. It sets your whole entire future. So definitely having somebody there to help like give you that structure that you might have not had access to, or those, information.
It's almost like a parental role.
Exactly.
Yeah.
Exactly.
DCF had said in prior testimony in years prior that there is a program that I believe it's the age of 15 where they try to kind of usher you through these now grown up years, so to speak, to get you prepared for when you have aged out of the system and if you don't want to apply for this. Did you go through that program?
No, well, somewhat, because I was a little close because I was 17 when I came into first DCF, so they didn't want to kind of give me those programs. They kind of just were like, you're gonna be old enough anyways, so there's really like no point to give you those programs. But like thanks to Stacy, she kind of pushed them to push me into those programs and helped me get into like I don't know if you're familiar with like the CHAP and share programs.
Tell us about it if you can.
It's like for use in DCF, and it just helps you with like the things that you would miss out on if you grew up in DCF. So like let's say like just basic like life skills, I guess would be the right thing to say. Yeah, she pushed that's something that you're talking about when with 15-year-olds, like to go out of 18 when you get out of DCF. She helped me like go into that, but DCF didn't want to like put me into it.
So let me ask you this. There's no right or wrong answer. It's really just for an understanding.
Right.
You came into the system at 17 and you're 19 now.
Right.
Would you say that you are a much different person at the age of 19 than you were at 17?
Oh, for sure.
Do you feel that you would be equipped to make choices at the age of 17, knowing or really not knowing what life is going to be like when you're 19 and out and aging out of DCF?
Definitely not.
Right.
Right. Yeah. Definitely not.
Well, I will tell you, you're doing a great job here.
Thank you.
You're very, very welcome, and we welcome.
Thank you.
Are there any questions from other members of the community? Senator Seminara.
Thank you, Madam Chair, and thank you for your testimony. It was, you're very well spoken. I just have one question. You talked about being put into a program to educate you about life skills.
Right.
Could you just share with us or give an example of what a life skill is? I'm just curious.
So specifically, like one of the first things I can remember working on in that program was getting into like college and secondary education, which is a life skill. Obviously, like going to secondary education could better your life, obviously. And they helped me with getting my license. They helped me with driving school, getting into driving school, and they helped me get my first apartment as well. So
would you say there was any financial guidance? I'm just curious. Do they
yeah,
teach you how to manage your own finances?
They did. They definitely helped me start like budgeting. They set up they helped me set up my first credit card, but I kind of like stepped back with that because yeah, like
Did they teach you that too? To step back from that? Okay, thank you so much. I just wanted to kind of get a little bit of a clearer picture of the life skills that they teach.
Right.
And best of luck to you.
Thank you. Thank you.
Good for you. Senator Mar?
Thank you, Madam Co-Chair. You mentioned in your testimony that you had learned advocacy
Right.
from watching your lawyer advocate for you.
Right.
And I just want to thank you for mentioning that because I think we can't do what we can't see.
Mhm.
And being able to see what advocacy will do will serve you as a wonderful life skill. So thank you for your testimony and thank you for that mention.
Thank you.
And ultimately, I don't know what you want to do for a living, but we have a great intern program here if you want to consider it. I'm just saying.
Oh,
You can come visit my office anytime.
thank
Yes, Representative Wheelander.
And as the chair of internship, I'd be happy to talk with you anytime.
Awesome. Thank you.
See what this advocacy thing does? That's fantastic. Any other further questions? Seeing none in person or online, thank you very much. You did a terrific job.
Thank you. Thank you.
Appreciate you being here. Julie Hall, followed by John Flanders, please.
Good afternoon, Madam Chair and distinguished members of the Committee on Children. My name is Julie Hall. I'm the Senior Director of Children and Family Services at Sarah Inc. And we provide early intervention services to the children in Connecticut through the Birth to Three system. And I was delighted to hear all of what Commissioner Bai had to say. And so I'm going to change my testimony a little bit to shorten and condense it. I have submitted written testimony for you as well. We have the same concerns in terms of the line items that she had mentioned in terms of who is responsible and how we partner with schools to help families transition from birth to three services to school-based services and exploring those as options. And I full-heartedly agree with her in terms of our role around transition. Not only, I feel like I'm doing a commercial, but not only have my an advocate for my program, I'm also a parent who goes through working with the school system with a child with disabilities as well. And so I've seen the table from both sides, so to speak. And education is absolutely so important for families. I think in reading the language, and maybe this is more of a question now than it was a comment before, but originally when it started talking about I think it's starting around line 64, about the expectation for providing information to families and children. We do that naturally as part of the process in helping parents learn to advocate for what their child particularly needs. And I guess I was questioning what the depth of that was. Is this a handover of responsibility from the school-based Part B services to Part C in sharing that information, or is this still a shared expectation that we have continued to do all along, wanting to set up this partnership relationship with families so that it's not seen as us against them, that families don't feel like the school is the enemy, and they have to fight for services rather than be educated to know what they can ask for and should ask for and should expect. So I'm glad to hear you'll be working with Commissioner Bai on the language around that. One of the pieces that I didn't hear so far today, though, was around line 90, 91. It talks about school being able to provide written materials in 5 languages. But my concern is what happens to the families that don't speak those 5 languages. From an equity perspective, I'm wondering if there's any language that could be included that would allow for those materials to be provided on request. Talks about school being able to provide written materials in 5 languages. Thinking about families that are speaking Haitian Creole, Arabic, and other languages, 5 is not very many, considering how many languages are spoken in the state of Connecticut. When it came to lines 74 through 81, the other piece that wasn't in there was any mention of parents' rights if families chose not to share their information of their IFSP. And I just wondered if that was if that was something that should be considered, and making sure that some families don't want their IFSP or evaluation materials shared for whatever reason. And
That is 3 minutes, if you can please summarize.
mandated that we provide this information. Beyond that, I think the big question for me as a provider is the cost, in terms of, I'm hoping that there's funding that's going to go along for providing the parent guide for special education to families that will cover this and support that. Bertha 3 businesses that are providing these services are doing it in a very unstable time at the moment. And I'm hoping that there's funding that will come to help support that process. Thank you. And
Thank you very much for your testimony. Just a couple of things. I'll answer your questions. The parents' rights, if they choose not to share the ISFB, that is already their right. So it's understood within the legislation, I believe, but we will double check that. Regarding the languages in line 91, those are the languages that are typically utilized in statute for these things that cover the great majority of languages spoken in the state. But absolutely, I think that anything can be given in a different language if that's needed. Google Translate can be a wonderful thing. But my only question for you is regarding the costs. How many, as a provider, how many of these do you think you would need to provide per year of the handouts?
I don't know that I can give you the exact data, but I can tell you I have 850 children in our program, and each child stays with us for about 11 months on average. And every month we're exiting probably 25 children at our program, and we are the 4th largest of the Bertha 3 programs in Connecticut. So each program would have a different volume that they would be going through. And it is obviously determined based on the age of the child at time of referral and how long they're staying with us.
Okay, so are you aware of how many pages the guide is?
I am not aware of how many pages the guide is.
So let's just say the guide is, I don't even know, but we'll check. But if it's like 6 pieces of paper, 12 pages front and back, it would honestly be a financial hardship to the provider to have to provide a Xerox of those pages to 25 families a month?
It could be, yes, it could be, depending on the program. We're already functioning at a deficit based on stagnant funds for the last 6 years, and with no sight of change until after our rate review is being completed. So typically those brochures have been provided by the state, but knowing that I believe when I reviewed the budget from the governor, there wasn't any funding increase into the Bertha 3 line item. And so I didn't think that was something that was budgeted into the plan. And I didn't really know that would be a program specific cost, or if that's an Office of Early Childhood cost.
And do you have, even if it's a ballpark estimate, of the percentage of families that you serve that do not have internet access?
I do not have a ballpark estimate for that. My company provides our staff with laptops and hotspots in order to be able to help families access resources online. But we want to make sure that they're able to have those, not just when we're there during a visit, but beyond that, because these are skills we're trying to support them to be able to have and grow, so that when they move on to Part B services, those rights and are still the same, and the process is the same, that they can go back and reference it over and over again.
Right. So, we have a habit of allowing these things to be distributed electronically. And so if you could get us some information that might look at that data so we can determine that, because, you know, I would love to always say that there's enough money in the world. But I do believe that this is important enough that the legislature should appropriate money to go ahead with this. But a greater understanding of what percentage of your families don't have access to internet would allow us to do that appropriately. So thank you very much. Are there any questions? Representative Comey.
Hi, Julie. How are you?
Well, it's nice to see you.
Nice to see you too. I want to thank you for bringing up the different languages. That's something I've been working on. With the Department of Motor Vehicles, actually trying to increase access for folks to get their driver's licenses. And one of the things that we've been finding out is that we base it on, here in Connecticut, we base it on census data, and our census data is only taken every 10 years. And I think the general thought is that a lot of our communities are undercounted as far as their language and their, how many folks are here. So we have this percentage threshold that we have to make, and in order to get things translated into languages, and it's been obviously there's a 10-year lag when you have, in my instance, I'm working with the Nepali community, and they are growing like leaps and bounds here in the state. And if we're only counting them every 10 years, and we may or may not be actually asking them about their specific language, we may just say, oh, are you South Asian, that sort of thing. So I just want to thank you for bringing that up. And of course, your budget concerns. I know how our birth to three system is not been treated as with the resources not by the state, has not been given the resources by the state that some of our other early intervention programs and things like that have been treated. So thanks for mentioning that. I think that was it. There may have been something else, but I think it's a little bit off topic actually. So maybe I'll pick up the phone and give you a ring, and we can talk about something else I'm working on. Okay. Good to see you, Julie.
Thank you very much, Representative. Any other questions? Seeing none, thank you very much. We appreciate you being here. John Flanders, please, followed by Stacy Schlief.
Good morning, Senator Mayor, Representative Linehan, ranking members, Seminar and Dauphiné. My name is John Flanders, and I am here in my capacity as the chair of the Legislative Committee of the Connecticut Association of School-Based Health Centers, and want to talk to you about House Bill 6643. As you are all undoubtedly aware, school-based health centers are on the forefront of providing medical, mental, and dental health services for students in schools. One of the services that we provide is to do assessments for students who are at risk of suicide and other mental health issues. The problem is that when we do this, unless there is another diagnosis code attached to that evaluation, Medicaid will not pay for the cost of that service. What that means is that that service is provided, and it is provided at no cost for the parents, but we don't get any reimbursement and have no hope of getting reimbursement. So that means we have to take resources from other areas and provide it in order to do this. We're simply asking that this vital work be considered a covered expense, and that we would be able to receive the reimbursement that would enable us to continue to provide appropriate services for students. Thank you for your time, and I'm happy to answer any questions that members of the committee may have.
Thank you, Mr. Flanders. Quite honestly, I have no questions because it's so simple. and obvious that it's necessary. So thank you for being here. And are there any other questions from members of the committee? Oh, it looks like everybody's agreeing with me. You got a point. We're working
Yes.
on
If it was complex, they wouldn't have had me up here talking about it.
it. Now, that's not true. But thank you. I appreciate you as always.
Thank you very much.
Stacy Schlief, followed by Michelle Picarillo. Thank you for coming up again. And we have been doing this for years. And I have to admit that there is some sort of something in my brain that I never remember if it's Schlief or Schleif.
Schleif.
Ah, I knew it. And
Like
maybe
life.
this will be the time. I mean, it's like we talk a lot. I don't understand why I have that block. So I sincerely apologize.
No problem. Good afternoon, Representative Linehan, Senator Marr, and distinguished members of the Committee on Children. My name is Stacy Schleif, and I'm here today on behalf of the Center for Children's Advocacy. As an attorney in our Child Welfare Project, I represent children whose lives have been intervened upon by DCF. The center strongly supports Senate Bill 1008. As the law exists now, Connecticut youth in DCF care lose their court-appointed attorneys the day they turn 18. These are attorneys who have represented them since the day they were first removed from their parents and placed into the state's care, and with whom they have long-standing relationships. Federal law gives states the option to extend foster care to age 21, and the majority of states, including Connecticut, have done so. However, while many of these states have also ensured a continuity in legal representation, Connecticut has yet to make the similar investment. My written testimony provides more substance as to why attorneys continue to be needed for youth in extended foster care. It also references the federal funding that's available to partially reimburse DCF and DPDS for these appointments. I know I won't be able to say anything better than Emily has already, but I thought I'd use my time today just to list a few examples of the countless stories of older foster youth that we've experienced. There was the 18-year-old who had been in and out of DCF care since age 2. She was placed in a group home, which ended up being involved with a trafficking ring, and was then moved to Solnit. She and her hospital worker called looking for help advocating for a discharge plan, as DCF had yet to find her a placement despite her being clinically ready to leave. An attorney was able to help navigate the situation and ensure her timely release. There was the 20-year-old who called looking for help in navigating an administrative hearing with DCF, who was looking to discharge her. She'd been in foster care since age 13 and had no one else to turn to now that she didn't have an attorney any longer. And her attorney was able, to help mediate the issues, enforce her rights in ensuring that DCF was following its own policy, and push for her enrollment in community college. There was the 19-year-old looking for assistance when DCF threatened to discharge her after a rough academic semester in college due to her declining mental health and inability to get to class. There's the 20-year-old who was looking to attend college after the department had determined she wasn't college material, despite policy indicating an obligation to pursue further efforts with her. The 19-year-old experiencing homelessness, thus making it difficult for him to be consistent in therapy or attend high school classes, and yes, who DCF was threatening to discharge as a result. These are just a handful of the youth who have been resourceful enough to reach out to us to ask for assistance. There are many, however, who go without. Those are the youth who we will never hear from, youth who may not have the know-how, the resources, the time, or the wherewithal to pick up the phone, youth who are already in crisis. These are our youth who will benefit from the passage of Senate Bill 1008, who that bill will be investing in to keep their court-appointed attorneys past age 18 without disruption, to continue overseeing their cases for as long as their involvement with DCF and the juvenile court continues. And I'd be happy to talk through any logistics or legalities of what we're hoping that this committee passes. Thank you.
Thank you so much. And that was such a really great list of reasons why I think this year has got to be the year.
Yeah,
it's got to be the year.
I mean, I would agree.
Especially post-COVID, right? We're kind of seeing how all kids fell through a crack somewhere. And we're working diligently to ensure that that doesn't happen. Why would these kids be any different? I think it's really important. I want you this year to be the year.
Yeah, I'd appreciate that.
And so a question not about the bill. A few years ago, you brought a lovely young man here
Yeah.
who was just amazing. How's he doing?
He's doing okay. He so by way of example, when youth such as he did reached out to us when I think he was maybe 19 or 20 at the time, and we were able to troubleshoot the issues that he was having to ensure that he stayed in DCF care, stayed receiving the services that he was entitled to. But that's I don't want to say that's all we were able to do for him, but because we're troubleshooting these cases of youth who call and reach out with these specific crises that they're in, we're in their lives for as long as it takes to fix those crises, but not to then stay with them beyond that. So I haven't talked to him in a number of months. I mean, last I heard he was doing well, but because there's not this ongoing relationship that we would have had we been their attorney all along, it's hard. Yeah. you
So
don't know.
while we want that ongoing relationship and this legislation would provide that ongoing relationship in the terms of this young man, it might be pretty good that he hasn't reached out.
Right, yeah,
Yeah, right.
that's a good way of looking at it.
If you do speak to him, would you kindly let him know
Yeah.
that we were asking about him?
Yes,
I
for
think
sure.
about him a lot.
Yeah.
That's a true story.
Yeah,
So
that's good. Thank you.
thank you. Are there any questions from members of the committee? Yes, we'll start with Representative Brown.
Oh, I'm sorry. I thought you. No, thank you. Thank you for your testimony today. My sister is an actual attorney. So she one day went into court and represented the actual DCF young lady. And stories intertwined. It ended up being her now kid, which is amazing. So
Wow.
so she took that upon her. So that's like my little sister. Both parents had passed away. She was by herself. So
That's
it's amazing. So just to hear the story is
Wow.
it's a wonderful thing. So thank you for testifying today.
Yeah, thank you.
Thank you, Rep. Roberts. And I like, listen, that was my bad. I won't do it again. Representative Wiehlander.
Thank you, Madam Chair. Attorney Schleif. Attorney Schleif? Is
Yeah.
that- Okay.
Well, yeah.
I would imagine that if we were to expand and continue services for this number of children, that there would potentially be a cost involved. But I recognize that as a concern that we all have to take into consideration. I was wondering if you could speak to the cost of continuing services for children who continue in DCF care versus the cost that our state and our communities may incur when a child does not have the resources it needs and goes into crisis. And if you could just expand a little bit on how you have seen early supports and interventions be helpful in deterring not just, I would say heartache and trauma and uncertainty for people, going through these situations, but also just the general cost of what it costs for rehabilitation, et cetera. So thank you.
I had included a footnote in my written testimony with a statistic that we had found in a report that was put out at the National Conference of State Legislatures, but they had found that there's a $2.40 return on each dollar spent on extended foster care when youth are able to stay in it successfully, not be discharged, earn a bachelor's degree or earn a degree. The youth we see, so the cost that we've estimated would be that there would be a $500 flat rate for each appointment over the age of 18. There's about 400 at any given time, 400 youth, 450, maybe 350 youth that stay with DCF past of age 18. And it extrapolated, I forget what we determined that would be around maybe $200,000. there is federal funding that's available to reimburse TCF for, I believe, half of that. And so it would be essentially maybe $100,000 to $125,000 investment. For youth to, I mean, it's a priceless investment, as you had pointed out, in their well-being and ensuring that a successful future. I wouldn't be able to put a dollar amount on how that success translates, but with having this continued advocacy to point out to them what they're already entitled to by DCF policy, whether that's their college education, help funding for apartments, rather than being whole. I mean, that's a much bigger drain on the system in the long term, having to support people experiencing homelessness, et cetera, and other agencies as well. So yeah, it's a upfront investment for a long-term reward, I guess.
No, I appreciate that answer very much. And I think it's really great that it's been proven that this is not only the right thing to do for kids and for the state, but also financially. So it seems to be a really smart way to move forward and make sure that we're making our state better, because that these kids, all of our kids have the opportunities to succeed. So thank you very much for that answer.
Thank you.
Thank you very much. Are there, oh yes, Senator Seminara.
Hi, I just wanted some clarity on the financial picture you just painted. You said $500 cost per visit?
Oh, no.
Okay,
Sorry.
I that's why I want to make sure I understand you correctly.
If I said that, I misspoke. Per appointment. So as it is now, when the public defender's office appoints an attorney for a child under 18 on a case, which they're all entitled to once the court gets involved, that's a $500 flat rate appointment. So, we had guessed it could be the same for once they're over 18, you get reappointed, and it's that same $500 flat rate. There are certain billable expenses for youth under 18. I don't know how that would work out for the over 18 group, but that was the anticipated flat rate appointment per a one-time appointment fee.
So it's $500 per appointment, meaning when the youth is appointed a legal person, an attorney,
Yeah.
$500 flat
One time.
fee, and that's, like, for lack of better words, unlimited visits.
Yes.
Sorry, I don't know how to ask other than that way. So $500 flat rate, and they have you essentially for as much as they need you.
That would be something, that would be what we'd propose. That's how it's done for the under 18 subset. Attorneys can bill for visitation when they go see their client. There's pretty limited things that they can bill for, but visits are one of them. But any sort of administrative advocacy or education advocacy or going to them with appointments, that's not stuff that right now attorneys are able to bill for. And at this point, I wouldn't anticipate it for this group. It's this one-time flat fee of, yeah.
Thank you. Thank you for that clarity.
Yes, thank you very much. Just for those who are watching, I think the confusion was in the word appointment, where we think an appointment is when you show up at a certain time, but an appointment meaning appointing someone.
Yes.
So just for the clarity of the people watching, that was the definition of appointment as you used it.
Yes, sorry about that.
No, that's okay. You're a lawyer.
Yeah.
And a good one. So I think $500 is a bargain for you. So yay. All right. Are there any other questions? Seeing none. Thank you very much.
Thank you.
Michelle Picarillo, followed by Cindy Jackson. Ms. Picarillo is with us via Zoom. Hello.
Good afternoon. Representative Linehan, Senator Marr, and distinguished members of the Children's Committee. My name is Michelle Picarillo, and my testimony today is in support of Senate Bill 1005. I currently serve as the secretary for the Connecticut Youth Services Association, the statewide association representing over 100 youth service bureaus serving 145 communities in Connecticut. In addition, I serve as the Human Services Director for the town of Cheshire the umbrella agency for the town's Youth Service Bureau, and I am a Connecticut licensed marriage and family therapist who provides mental health services in a private practice. Thank you for the opportunity to speak to you today and for the time and energy that has gone into the development of this important bill. I'm here to express my support for this bill and to recommend that CYSA have a voice in this process should this bill pass. After several years of the mental health services in our state being pushed beyond capacity, the pandemic has left our country, state, and communities facing a level of trauma, the impact of which has only begun. There is a consistent and highly concerning increase in youth reporting that they suffer from anxiety and depression, in mental health related emergency room admissions for youth, and in youth substance abuse as our young people struggle to manage feelings of confusion, isolation, fear, grief, and social and school anxiety. As the number of youth in crisis is on the rise, accessing mental health services has become increasingly more difficult, with waiting lists often multiple months in length and hospital beds scarce. I've witnessed this directly in the different capacities in which I serve youth and families, and have watched parents crippled by their inability to access treatment for their children, and children facing significant mental health challenges without being able to access the necessary support. A statewide study of this nature is essential to understanding the comprehensive needs of children in the state, and the proposal of this bill is a testament to the Children's Committee's commitment to Connecticut's children. The post-pandemic world presents many new and significant challenges for youth and families, and the study will help us to know how to navigate these challenges effectively. The study proposed in this bill will allow our state to identify strengths and weaknesses, to prioritize needs, and to ensure that we are utilizing resources in the most effective way. CYSA has an important contribution to make to this process, as the state's youth service bureaus are the agencies positioned to respond to youth and families in crisis. It is my hope that Senate Bill 1005 passes and that we can work together to better understand the needs of young people in our state as they navigate through these challenging times. Thank you.
Thank you very much. Thank you as always for your work. I have to say that we're looking over this bill as you're talking, and I think that it's currently a work in progress. We recognize obviously that there needs to be this continuing study. So the committee had already kind of put together this task force, and now we want to continue it. I do know that your group is currently in the midst of working on this exact thing, and the hope is that the data from what you guys are doing can be used for this task force to help further the things that the questions that we need answers to. Can you talk a little bit about the data that you guys have coming in, who's doing it, and kind of where that is in its process, so that the members of this committee can understand the benefit of having that available to the task force that's already created?
So in a bit, you'll be hearing from Justin Carbonella, who's the Youth Service Bureau Director in Middletown, and his community is actually doing a study just like what's proposed in this bill. And I know that he'll be able to give you a lot more of detailed information about that process and about the kind of data that's being collected. So I'm going to sort of push it over to him, because you'll be hearing from him in a few minutes, and he has a lot more accurate information as he's directly involved in the process. But I know that he has several partners who are working with him to develop the study, and they have a comprehensive plan for collecting this data. And I know part of our plan through CYSA was to have that data shared with the task force.
Great, thank you very much. And again, thank you for all of the work that you're doing. Previously, I don't think you were on yet, but we did have the Office of the Child Advocate here in Sarah Egan. And she did talk about the Youth Risk Behavior Survey that as the data has recently come out with the most latest results of that. I know that I've worked with you in the past regarding this survey, and you understand the benefits of that. I was very glad that this committee was able to add an adult sexual misconduct question just last year, and I recognize that that's coming out soon. But the question I have for you is, have you had an opportunity to see that data yet?
Not this year, no, I have not.
Okay, so what she said was that across the country, that the age of suicidality and a plan for suicide is still decreasing, not the number of kids, but the average age, which has that. In your multiple roles, are you seeing younger and younger children with suicidal ideation?
Absolutely. And one of the things that I will tell you, so if I just look locally, we have a crisis intervention unit as part of my human services department. And so when there is a call in our community to the police or to EMPS, we get notified and we do follow up with resources and whatnot. And what we are noticing is that the ages of the children that are being referred to our department, which typically used to be adolescents in middle or high school, we are now seeing kids as young as kindergarten and first grade. And those referrals are increasing on a pretty regular basis. And we're seeing similar patterns in my private practice as well. So yes, I am seeing that.
So that completely breaks my heart, especially because it's my community.
But it's also, I think, a function of, the inability to access treatment too, because I think as older people and like parents and older siblings are struggling with mental health challenges and not able to access treatment, that sometimes trickles down to the younger members of the family. I also think access to social media presents significant challenges in this area. And as younger people are becoming more exposed to messaging on social media, these types of mental health challenges are increasing as well.
I wanted to ask you, and I think technically I'm not supposed to yet, so I'm just going to put it out here. We will have a bill that is up for the public hearing, I believe Thursday, regarding a handout that it would be for, and we just voted on it yesterday to go to a public hearing, that would be for cafeteria workers, not to be trained in recognizing eating disorders, but simply to be given the tools to have conversations with students that don't trigger eating disorders. And I'm going to ask that you take a look at that. I will send it to you. And if you're available, if you could testify on that and let us know if we're on the right track.
Sure. Please send it to me. I'd be happy to look at it.
Great. Thank you. Thank you. Are there any other questions from members of the committee? Nope, seeing none. Thank you so much, Michelle.
Thank you.
Cindy Jackson, followed by Elaine Balsley.
Hello, Representative Linehan, Senator Mar, and distinguished members of the Committee on Children. My name is Cindy Jackson. I am chairperson of the Birth to Three Interagency Coordinating Council and Director of Children's Therapy Services, a state contracted Birth to Three provider. Thank you for the opportunity to offer testimony regarding House Bill 6644. And I also want to thank Representative Linehan for your support of Birth to Three in the past, and Senator Mar for your future support as our newly appointed ICC member. Although I appreciate the intent of the proposed legislation, I'm in opposition to the way it's currently written. As a Birth to Three provider, I think we agree with Commissioner Bai that the intent is great, but the specifics of it do, as a Birth to Three agency, concern me. As you know, one of the most important things we do in our role is to assist the parents in a smooth transition for Birth to Three, which is Part C services to Part B services and special education, as well as community resources. And what our role really is to do is to build the confidence and capacity to have the parents be great advocates for their child during this process. And we begin this at 2.5 years of age, and we work through those last 6 months, working very closely with the school system. And many of the things that are written in, as Commissioner said, we're already doing. I think the concern is overall purpose does not take into account the collaboration that already occurs. The proposed changes require Birth to Three service coordinators to have extensive knowledge of Part B and take on additional responsibilities of educating families about these services. When we're at the table during transition conferences and IFSPs and PPTs, we really want it to be a collaboration, and having the school system present at our transition meetings, they are the best person at the table to really be the most knowledgeable about eligibility, the IEP process, and the services and resources available in their district. So to put the requirement on the Birth to 3 service coordinator, although they're there to support the family, probably isn't the best person at the table to share that information. So the additional training and paperwork requirements, again, under this proposed change, go unfunded. But to me, we really want the parents to start building the relationship with the school system. And that's why I think it's really important that they're the ones sharing the booklet on special education, because they're the ones that can explain it to the parents the best. So I think the intent is great. I can follow up a little bit on Julie Hall's information that she testified in, and some of the questions you had, Representative Linehan. We have about 4,000 families that leave Birth to 3 each year. And actually, that was in fiscal year 2022. 232 were eligible for Part B, and then the other about 2,000 were either stayed in Part C through that over 3 period of time, or went through the process, were not eligible, or went through the process and just were not determined at that time because they're probably a late referral. So we're talking about 4,000 people, families. The special education guide is 60 pages long. And I do want to just mention what Julie mentioned about the parents' perspective and native languages. Last year, the top languages in Connecticut in Birth to 3 were English, Spanish, Portuguese, and then we went to Creole, Arabic, Urdu, Hindu, Albanian, Mandarin, and Bengali. Each year, the ICC has an annual report where we report out what are the top 10 languages of our families. So I don't know if that information could be helpful in deciding on what, what is translated and interpreted for families. But I'd like to thank you again for all your support, and I can have any questions.
Yes, thank you. Thank you so much for being here. I'm just so glad. It's like my district is so well represented. And it's great to have so many knowledgeable people. And so we're sitting here as you're giving your testimony, we're trying to figure out how to fix this. So I'm going to pose this question to you. And if you don't have an answer now, call or text.
Yeah.
But so the issue is that the advocates that came to us are saying, okay, look, we've got these kids and they're in the Birth to 3 system. And then they're meeting with the school system about special ed. And the school system is saying, nope, we don't think you're a special ed candidate. So what was it? Was it last year, the year before, we decided that we were going to have the Sparkler app. They had to get information about Sparkler so that parents can go, all right, well, we didn't qualify, but here's some things we're still concerned about their development. So we're going to follow on this app and everyone's going to stay in touch and we'll talk about that. But I think now what's happening is they're coming back and saying that there still is no one to advocate for the kids, and that the onus being on the parents is too much. Like and I'm sure parents are overwhelmed and not always the best advocates because these kids are so small that they haven't been doing this for years yet and haven't figured it out. And special education is really expensive. So the fear is that it behooves the district to say no more than it helps the child, right? So who's going to advocate for this child? We're trying to educate the parents, but then they're missing this opportunity. So I think we're having trouble deciding how to help these parents who, because it's rough going out there trying to get a PPT for your kid. And so I know you probably don't have the answer now.
Yep. Well, I do think one of the things, and it has been our emphasis in Birth to Three, is to really develop the family as advocates. So when we go to that transition meeting, we're not the ones explaining about the child. We're not the ones giving the evaluation IFSP. We're supporting the family and being able to share that information and advocate for what they feel their child's priorities and needs are, with us there to support them. So hopefully, age 4, when we're not there, they have those skills. And so that's why I do think Birth to Three is helpful in that way. What needs to develop at that point is they need to feel like they could develop that relationship with the school system then. And that's kind of, I think someone else had mentioned, we don't want it, like it has to be a fight to begin with. We want them to develop that partnership so that they know they can go to the school and really discuss priorities and strengths. And when that doesn't happen, I would say Connecticut Parent Advocacy, CPAC, is the best agency that is funded with the state to be that advocate for the child, for the family. They don't have to pay for it, so they don't have to, at some point, some have to get attorneys, but hopefully that service can provide that support again for the parent to be that advocate and develop that, working relationship with the school. I'm not sure giving them 60 pages to read is going to be helpful. But for some parents that works. Some parents calling CPAC is important. Some parents still call Birth to Three. I have 4, 5, 6, maybe 8-year-olds that call us and say, what do you think? But our role is to really support them developing that collaborative relationship with their school system, because they're going to be there for, 18 years.
Okay, so this is extremely helpful. And so is there anything, whether it be in statute or best practice, that requires information about CPAC to be given to parents at any time in the process? Or should we create that?
I think it can, if this goes through, have that as some wording in there that's where parents need to go. I can tell you in the form that you mentioned for if a child is not eligible, we always give that information in the what is it? The form we do. I have it written in my written testimony. I have the form that we give when children are not eligible for services. Within that, it does authorization to include, no, the next one. School district contact information if a child is not eligible. That in there's an area that we could put in CPAC as an option, which we typically do with our families. Maybe that's something in the initial meetings that the IEP, during the IEP process, that could be shared with families. That actually the document you're talking about is actually housed at CPAC. It's on their website. It's readily available there.
I am so fortunate as a co-chair to have a co-chair who knows all this, and now also to have a Senate ranking member who knows this too, because this is not my realm. But it seems that when we all put our heads together, good things can happen. We certainly don't want unintended consequences. We certainly don't want the wrong people doing the right work.
Right.
Or right people doing the wrong work. So it's really just a process of this is why the public hearing process is so great. So we can kind of figure this out. We are going to have to talk to the advocates, because I also need to make sure that we are completely understanding their concerns, because some of the things that you guys are all saying, it sounds to me like maybe their concerns aren't concerns at all. I don't know. We'll have to continue to work that out. But once again, we might be asking you to come to a meeting. So, fantastic. Thank you so very much for that. Are there
you.
any questions?
Representative Comey.
There you go, Representative Comey.
Hey, thank you, Cindy. Thank you for your testimony. Well, so I'm glad you mentioned the children that are not eligible. I briefly, in the children that are not able to move into, you know, into the services that the schools offer, do you have an estimate as to what percentage of those kids that you see that are aging out of your birth to 3 system and are not eligible? And can you describe what then happens during that 2-year time period to those kids, and how do they, you know, fall further behind? And can you just talk to that a little bit?
Sure. I'm just adding up in our last report. There was 631 children. This is again just fiscal year 2022. There were 326 that were not eligible for Part B and exited to other programs. So they might be in a school, you know, readiness, early Head Start program, something like that. And then there were 305 that were not eligible for Part B and exited with no referrals. At that time, the parent did not choose to, you know, go to another preschool, and they might just be in a private preschool. And then there was another 527 that were eligible for Part B, was not determined. And that, again, those are kids that come in very, very late into our system. So that's, you know, probably 631 for sure are ones that we know are not eligible. Some of those children still have a delay. And typically what we do is hook them up with either outside agencies. If it's the delay is in like a gross motor, fine motor, speech and language, we will give them outside private agencies that would, you know, provide direct services. And then we work with them if they're going to, you know, hopefully be in some type of educational program as well. But there are, you know, there's no doubt there are some children that show up in kindergarten that we probably knew were going to show up in kindergarten, you know. But I think the issue with birth to 3 and with, you know, school system is we have eligibility criteria. And Connecticut's pretty strict for birth to 3, and, you know, pretty strict for preschool special ed as well. So we have never provided in Connecticut at-risk services under birth to 3. Obviously, there's some home visiting and other things, but we've never provided at-risk services. So there are children that I know we evaluate at 11 months that don't meet eligibility and might show up again at 28, 29 months. Then they're delayed enough, you know. So that's systemic in what our eligibility criteria is.
And to your point, they don't, they join your, they've sort of snowballed into not being eligible. Then they become eligible very late in the birth to 3 process, and they begin getting services from you, and then are not, for one reason or another, may or may not have gotten those services soon enough. And then you're cutting off the services, and you and then waiting for their time to go to public school. And so when you refer them, you mentioned you refer them to direct services. The direct services that they're receiving would be paying out of their own pocket.
It would be health insurance, Medicaid, but sometimes depending, yes, it could be, you know, it could be out of pocket depending on what their health insurance coverage is. But yes, that happens, and obviously they pay for their, you know, preschool programs if they're not eligible.
Sure.
But I do think eligibility is an issue. It's a very expensive issue to address, to opening up to, you know, a lighter eligibility criteria or, you know, treating or having at-risk children in the program. We do now birth to 3, you know, if they're in birth to 3. We had, let's see what it's here, you know, over 750 that no longer required special ed services or birth to 3 because of the early intervention. So we know it works. The other issue right now is we know we have a workforce shortage in birth to 3. Recruitment retention is a significant issue. So to, you know, increase eligibility or increase services to those children over the age of 3, it would be stressful on the system, although we would all want it to happen for sure. But right now, you know, recruitment and workforce is a really huge issue for us.
Yes, I understand that, absolutely. And across the industry for sure. Well, I have a bill for that in education, so I would love you to come and testify when that comes forward in education, because I have also, you know, working with the advocates and the providers, we've determined that that is a significant missed opportunity, I think, for our state and for our kids. So thank you for sharing, and great to see you.
Thank you. You too. Thank you.
Thank you so much. Great conversations happening here. I just, I did get some information, which I think is kind of funny, to be honest with you, and not in a good way. IDEA requires that CPAC's contact info is on the IEP form. It's in 8-point font. 8-point font. I have to tell you that I have like glaucoma font on my phone and I still have to make it bigger. I can't, 8-point font is ridiculous. So that's something that maybe a very small change would make a very big difference.
Well, we also have Connecticut SEDS, which is the whole new IEP system in the state, just rolled out in the fall. You could look at that. Everything is online now for families as well. So, you know, I don't know if you want to speak with Department of Ed on CT SEDS and see where it's at, where it is on there, and if it can be in a few other places, because the access to parents with this new system is greater. So there might be other places within where they can kind of stick that in.
So Cindy, I'm going to be honest with you in a very public way. My child was in an IEP. I haven't looked at that system yet, and I should have. And
it's confusing for professionals right now. So I'm sure for families it's confusing as well.
I signed in once and I was like, oh my God, I can't handle this right now.
Yeah.
And so you know, I recognize that the school district is thinking this is the greatest thing since sliced bread. I have to say, I don't agree. So, and now you're talking
a huge learning curve for everybody.
Yep. So, but it is in glaucoma font when I look on my phone. So at least there's that. All right. Are there any other questions? Nope. Seeing none. Oh, I'm sorry.
That's okay.
Yes, Senator.
Just wanted to say hi to Cindy and thank you for your testimony.
Thank you. Thank you for joining ICC.
Great. Thank you very much. Appreciate you and your time.
Thanks.
And next we will call Elaine Balsley. Okay, Elaine is not with us. We'll have Crystal Rich followed by Melanie Wild Lane. Okay, we're striking out here, folks.
We
I
actually,
believe Elaine just signed on.
I'm sorry, Representative Comey, I didn't.
I just saw Elaine sign on.
Oh,
I did.
great.
I just signed on. I apologize. I'm
That's
a little
okay.
bit I'm a little technology challenged. Good afternoon, Senate Mayor, Representative Linehan. Thank you for getting my last name correct. Not everybody does that. And good afternoon to distinguished members of the Committee on Children. Thank you for listening to my testimony today regarding HB 6644. And thank you for all your work on behalf of children and families. It is so important what you do. My name's Elaine Balsley. I'm the director of Reach Out, which is a not-for-profit business that provides birth to 3 services. I am in agreement with everybody that has come before me, the commissioner and my colleagues in terms of liking the intent of the House bill, but having concerns. I think birth to 3 staff are keenly aware of how difficult transition from birth to 3 to special education is for our families. And we really know that parents do need to know their rights. The language is complex. You know, that 60-page document is almost unreadable. And I know that some of the language in that, maybe all of it, and I know some of the language in our parent rights is required by the Office of Special Education. But having a parent guide to special education in Connecticut that maybe was able to piggyback on that was actually readable and understandable, I think would be a huge benefit to our families. I also want to say that we routinely recommend CPAC. CPAC is on our IFSPs. We also recommend, there are other family support services in Connecticut. There's PATH, there's Parent to Parent, and there is the Connecticut Family Support Network. CPAC does have a contract, I understand, with Office of Early Childhood, but those are other not-for-profit businesses that are very helpful for families. I agree with Cindy's testimony that the Part B is better explained by the people who provide those services. And for the Part B children, I'm sorry, for the birth to 3 children who are ineligible for Part C services, we still have a transition conference. We are required to have a transition conference. So they may not be eligible for special ed, but that's where we discuss next step. That's where we talk about what's going to happen in the next couple of years. Do they go on to a Head Start program, a school readiness program? Do we help them get private services until they're ready for kindergarten? And then I also agree with Cindy about we get referrals for kids who are 9 months old and they don't meet eligibility requirements. They're not delayed enough. And then they come back late. And, you know, we could have gotten them earlier, and maybe they wouldn't need special ed. We do exit an awful lot of kids who are not eligible. I mean, Cindy had the numbers. I'm on the ICC as well. I don't have the numbers in front of me. But that's sad, and it's actually costly to towns. I mean, I know you all know in your towns the cost of special education services for children starting in kindergarten, and birth to 3 is a lot less expensive. But we are businesses and we're trying to run a business, and there's a serious staff shortage. We can't retain staff. We can't hire staff because of funding issues. We haven't had a reimbursement change since 2017. I'm not going to go into detail about that. I realize that's more of an appropriations committee issue, but I think that your committee just should be aware of those challenges. So I'm going to leave it at that, and thank you so much for your time and energy to all of the children and families in Connecticut.
Thank you so much for your testimony. We appreciate you taking the time, and we are all technologically challenged sometimes, so no worry about that. Are there any questions? Seeing none, thank you again.
Thank you.
Crystal Rich, followed by Melanie Wild Lane. Melanie, are you on? We don't see Crystal. Thank you. Go
I
ahead.
am. Good afternoon, Senator Marr, Representative Linehan, and members of the Children's Committee. My name is Melanie Wild Lane, and I am the Executive Director of the Connecticut Association of School-Based Health Centers. I come before you to testify on behalf of HB 6643, an act concerning Medicaid reimbursement for mental health and suicide risk assessments conducted at school-based health centers and at schools. I'd first like to thank Sarah Easton, who provided amazing testimony and data, and John Flanders, who is our right-hand person at the Association for Advocacy. So I instead I'm going to divert from my testimony, which will inundate you with data, but Sarah did it for me. And instead, I'm going to read to you testimony from Jason Kirsten, who is an LCSW at one of our Torrington school-based health centers. And so you can sort of wrap your brain around the impact of what this bill will do. So I'd like to share a story about a high school student enrolled in our school-based health center. She's from South Africa, was raised by her grandmother, and came to the US just over a year ago to be with her mother. She's a good student. She works hard. She studies hard, plays soccer on the soccer team, but has struggled with her relationship with her mother, which is common for children who have been separated from their parents and reunited a decade later. She was forced out of her home that she shared with her mother due to that relationship, which threatened her well-being, education, and social group of friends that provided her with support. The student had the support of the school-based health center as a member, and through the Community Health and Wellness Center in Torrington, along with the collaboration of teachers, school social workers, guidance counselors, behavioral health, and medical providers at the school, we all came together, and within 12 hours, housing was secured for this student for as long as she needed, which is amazing. The student also had access to medical and behavioral health services through the school-based health center, offering these supports, which were established prior to the child being forced out of her home through the assessments that they had conducted. Takes a great deal of collaboration and community partnership, and a caring school faculty and staff that are supporting the child every day and assisting the school-based health center with achieving good outcomes for the children in Torrington and across the state in our school-based health centers. The assessment of the student and the family's needs, along with the incredible collaboration to address those needs, is what makes this a success story. The fact that services were taking place in the school allowed for quick access and communication with the situation as the situation escalated. And working with the student and family for over a 6-month period of time has given her the ability to reunite with her mom. This story is an example of why this bill should be supported. The case management time, and I'll just go off his testimony. The case management time invested, and we call case management the risk assessments because we're not reimbursed for those services. So anything outside of a traditional office visit is case management, that collaboration, the risk assessments, the coordination with outside resources and partners to get these kids their basic needs is what we deem case management, and we are not reimbursed for that in our school-based health centers. And it's a huge amount of what we do. It's more than the actual visit. So as noted, a mental health wellness examination, if you look at the bill, it outlines all of these things, right? And so it's supposed to be 30 minutes, a 30-minute assessment. But in that 30 minutes, our providers are supposed to do an assessment, an observation, a behavioral health screening, education, consultation. It's going to take me 30 minutes to read off all of these things that they're supposed to do. And so they do it outside of that normal time. Again, it's not reimbursed. And if you were to go and have a risk assessment done by your provider, you'd get an explanation of benefits from your insurance company. Your insurance company pays a set amount, and then you're responsible for the rest. Well, that's not how the school-based health center works. There's no out-of-pocket costs to the families. And so We do these risk assessments every single day, both in medical and behavioral health. And all we are asking is that Medicaid be able to reimburse us for those services so that we can, on a regular basis, do these consultations and assessments. So I thank you for your time. You all will listen to me talk insatiably over the next few months, but I appreciate it. I'll take any questions you have.
Melanie, thank you for your testimony. I do have experience with school-based health centers, and I know that what you're saying is absolutely accurate, that the community comes together to support the children and the students. So thank you for your testimony. Are there any questions from anyone on the committee? Seeing none, thanks again.
You got it. Thank you.
Susan Myers, followed by Rashini Youssef. Okay. Rashini, I believe you're up.
Hello.
Thank you.
Okay. Hello, Representative Linehan, Senator Marr, and members of the Committee on Children. We have a special greeting for Representative Roberts as well, who represents our interests in Norwalk. Student activists in Norwalk and Stamford have come together in support of HB 6642, an act concerning a Title IX compliance toolkit for school districts. We are grateful for your attention to students' rights in Title IX investigations. My name is Roshni Youssef, and I'm a member of the Center of Youth Leadership at Brett McMahon High in Norwalk, and I'm speaking on behalf of the center and our allies at the Mayor's Youth Leadership Council at Stamford High School. Our members use public awareness campaigns, volunteer programs, and social change campaigns to address several issues, including students' rights, sexual assault, and sexual harassment. Each year, we choose one or two school board policies and regulations to update, revise, and make more student-friendly, with an emphasis on student rights. Over the past few years, we have updated policies and regulations about the dress code, access to cell phones on campus, and the rights of transgender students. This year, we decided to review Title IX. To our surprise, we discovered a gap in the regulation. It says that students can report a sexual assault to central office administrator or a school principal, but it does not include a step-by-step process for principals to follow when investigating a student's allegation of sexual assault by an adult or a classmate, nor does it address students' rights before, during, and after an investigation. We're researching and writing a step-by-step process for principals, which includes the professional development opportunities available to principals and school officials, and, if any, the role of school resource officers. We hope that these and other topics will be addressed in the toolkit called for in HB 6642. We are happy to see your inclusion of the rights of students throughout the bill, especially in lines 32 to 37, which addresses the safety planning and how students can submit a complaint and their rights when doing so. And we were also pleased that you cited the United States Department of Education training guide for administrators and educators on addressing adult sexual misconduct in a school setting. And as you know, the guide includes a broad set of behaviors that take place in school settings, ranging from those that are inappropriate to those that are illegal. This is key because the behavior of some adults, as reported by classmates, are usually not criminal, but as the guide says, they're often violating regulations and unprofessional, like they violate regulations and professional codes of conduct. And this includes sexual comments or jokes directed at students and sexual teasing with a student, often in front of other students without any fear or retribution. Finally, please see lines 15 to 18 regarding research and data collection. You cite the protection of students with disabilities or students who are lesbian, gay, bisexual, transgender, queer, or another sexual orientation or gender identity. And you may want to consider including the experiences of ELL students who have been subjected to adult sexual misconduct. ELL students are vulnerable to this misconduct because they're rarely told they have rights and how to exercise them. And again, thank you for the opportunity to testify.
Thank you so much for your testimony, Ms. Youssef. We appreciate the fact that you came together with Brian McMahon and Stanford High School to be advocating for this and for your research into Title IX and this bill in particular. So looking at the committee, are there any questions? Seeing none, thank you again for your testimony. We really appreciate you.
Thank you.
Chris Oakley, followed by Paul Tarbox. Chris?
Yes, thank you. Just a quick moment. I'll be joining you with video. Thank you. Sorry, I had some technology issues. I had to change to my phone. So can the chair and the members of the committee hear me?
Yes, thank you.
I apologize. So I just want to say thank you to the chair, the vice chairs, the Children's Committee members that are here. I am the Connecticut Bar Association legislative liaison for the Child Welfare Juvenile Law section. And I'm here to support Bill 1008, which was testified to earlier about having attorneys represent children post 18. Frankly, I can give numerous examples as to why this would be appropriate and would be helpful for kids to have this. The one concern that I just want to bring to the attention of the committee is, I think you would know, but there's frankly been a mass exodus of panel attorneys doing this work over several years, some prompted and maybe increased by COVID. And then some of it, frankly, is due to compensation, issues, and then others is just others move to fatigue on the attorney's parts, and they're moving on. OCPD would have the more exact numbers, but I think their numbers are down 40%. I've done the training for some of the new panel attorneys over several years, and the number of new attorneys entering this field continues to be less and less, and there's more exit than entry. So it's challenging work, it's good work, it's meaningful work, and most of the attorneys that do this do not do it because they want to get financially rich in it. Myself, I do other areas of law, and I really, this is almost, we call it low bono. It's an attempt to help services out. But the short of the testimony today is we just want to bring to the light that we think that this is a good bill, but it would have to be adequate compensation really because if you just gave it and said, here, do it in addition to all the other work, and like the panel heard earlier, there's a $500 flat rate fee, and these kids are being represented for 3 years. And what are the expectation of the attorneys? How much work are they going to put in for this $500? And then a whole nother question is whose malpractice insurance is going to cover any work done on these areas. I will finish by saying typically I tell kids that I represent when they turn 18 that they're always welcome to call me, and I can try to help them, even though it's not going to be any formal representation moving forward. But that, I think most attorneys do something like that, but I'll be frank, we don't keep a continuous tabs on the kids when they turn 18. And that, I think, is in and of itself would be a benefit. Thank you for your time, and I'll take any questions.
Thank you. I do have a question straight away, which is, I believe that when we heard earlier from Stacy Schleif, that there are other billing times that the attorneys can do. It's not if they're having conversations with this, the person, but when they are doing, not when they're going visiting to meet with them, not when they're having a conversation with them, but I thought I heard her say that there were other opportunities for billing. Is that incorrect?
So there are other opportunities. So, and I'll speak to as what the current under 18. They are in-person visits. So if you meet with a child in person, you do get a bill for your time. If you have a trial, you are able to bill for that trial time. And if you have what's called an administrative hearing, which is a treatment plan, there may be some dispute as to what the treatment plan should or shouldn't be for your client, the child. Those activities are billable at an hourly rate. It used to be $50 an hour, and then it was fairly recently, which we're appreciative of, moved up to $65 an hour. And every case is different, so I don't want to overly generalize, but it's very, it's expected a lot of these cases will take somewhere between 20 and 40 hours to work from the time they begin to the time they end. So, you know, using rough math, maybe 30 hours of that are covered, and approximately 5 or 10 of those would be billable. So that's the quick breakdown to answer your question. Thank you.
Okay, thank you so much for clarifying that. Are there any other questions? Yes, Representative Wieslander.
Thank you, Madam Chair. And thank you, Attorney Oakley, for being here today. I just wanted to touch base on a couple of points that you made and wondering if you could expand upon it a little bit. Right now, are the expectations not clearly laid out from the get-go on what would be expected from an attorney in doing this work?
Sorry, I was on mute. Sorry. So we are technically independent contractors. We're not like employees of the Office of the Public Defender. There is definitely orientation training that's given to all new panel attorneys that accept the contract. There is CLE availability, and I know OCPD actually posts on its website. Apologize. There is on the OCPD website the policies which lay out what the attorney should be doing as far as visits and contact.
Okay. Do you think this is more of an opinion question, in your experience, if the expectations and the responsibilities were laid out more clearly from the beginning, do you think that that would be helpful in the recruitment and retaining of these attorneys in doing this work?
So it's a good question. I think I would want to think about it a little bit before I simply respond. And I apologize. The office I'm in, I've had to step outside, for this call. I had hoped to be in a different location. I think most of the attorneys that do this know about it. I mean, I guess the question would be the recruitment piece that goes to your question. I think giving people a clear expectation of what is required in this work is appropriate and is helpful. To be frank, though, I think it's the compensation piece. Most of the attorneys that have done this for a period of time are being hired by the Attorney General's office, DCF staff attorneys. They're leaving this and going to other more lucrative, and I don't want to say necessarily all those jobs are financially lucrative, but in comparison to this work, it is.
Thank you for that. I think if we are wanting to look at responsibly expanding this type of coverage, then we do have to make sure that we have the personnel to actually fill the positions, because otherwise we're just tossing an idea into the wind that won't actually be able to help the kids, which is the main goal. So thank you for that. And I appreciate these items you've given us to think about. Thank you, Madam Chair.
Thank you. Any other questions? Seeing none, I want to thank you for your testimony. We very much appreciate, even under the circumstances that you've had to deal with. Thank you, especially because of the circumstances you've had to deal with.
Thank you.
Next up, we have Paul Tarbox. Hi, thank you.
Good afternoon, Madam Chair. My name is Paul Tarbox. I'm the Director of Public Policy and Communications for the Connecticut Council on Problem Gambling. I'm here on behalf of our Executive Director, Dinah Good, We wanted to support House Bill 6641. Essentially, we provided testimony on that kind of outlines our positions and some of the facts about youth gambling. But to kind of quickly summarize, with having the largest expansion of gambling in the state in the last 30 years happen the last couple of years, we've been working hard on strengthening what we like to call the problem gambling safety net. And in an effort to kind of keep youth from having access to lottery tickets, we think it's probably a very smart and important step to provide the same type of safety protocols for nicotine and for alcohol, to require licensed providers to essentially card people that they think might be of the age. I did get a chance to hear my good friend Chris Davis's testimony before, talking about how it could be an unnecessary burden. And while I agree that a lot of times people are given lottery tickets, scratch offs through friends and family, I would also say that I've been buying alcohol since that law was passed, and there's plenty of times where I'm not actually carded. So I think many times just because the law says the fact that it's a mandate, they're not going to always be doing it. So it's probably better to have it be a requirement that some people ignore than have it be a permissive language where most people ignore. Additionally, we had a request for substitute language on a problem that we're kind of having when it comes to the ability of kids that are 16 and 17 years old that find themselves getting in gambling related troubles, where they don't really want to loop their parents in yet, but they're looking for kind of access to treatment, or at least hear what's available before they loop their parents in. And one of the problems is that we're not really able to refer them to certified gambling counselors. So we would love if that was something that could be considered in this bill or another, just to allow those kids that are kind of getting in trouble to hear the information, get information about voluntary self-exclusion, and be able to potentially go to treatment with or without their parents, depending if they're comfortable. With that, I'm happy to answer any questions, and I appreciate the committee taking the time.
Thank you so much for your testimony. Are there any questions from the committee? Seeing none, thank you again.
I'm sorry, I have a question.
I'm so sorry, Representative
Okay.
Comey. Please go ahead.
So what, Paul, you mentioned the 16 and 17-year-olds that may be reaching out to you for treatment. What is holding you back? Can you explain the legislation that the policies that are making that not possible?
Sure, they're kind of they're currently in like a gray zone, because they're the way the regulations currently stand. If they're under the age of 18, they would typically be under DCF, but it's not a program that DCF currently offers. And through Department of Mental Health and Addiction Services, it's 18 and above. So the typical answer is, well, we need to kind of loop your parents in or refer you to DCF, and generally both of those usually end the call pretty quickly. So we're just looking for an opportunity to kind of allow them to be in these conversations without parental consent for people that are essentially 16 and 17, just because it'll give us access to those certified gambling counselors to be able to talk about the different treatment options, and whether they enroll in treatment or not. Obviously, they would need to probably have their parents at that point, but at least having those conversations could be beneficial.
Thank you so much. I appreciate you bringing that to our attention. Is as you work, I'm sorry, just looking at you're with the Connecticut Council on Problem Gambling. What have been your conversations internally or with the different agencies involved? Has there been any solutions tossing around? You guys are the front line, so I'm just wondering if there are any solutions that you've thought of that before we start, going down a different path or maybe a similar path.
Sure. Well, essentially, I mean, we get a lot of calls to our helpline. We operate the state's 24/7 problem gambling helpline. And if it's just, offering kind of, harm reduction strategies, like how to, if you're going to gamble, how to be safe, whether it be like having a set aside amount of money or potentially kind of not chasing losses. I mean, we still do those things, but if it's the point where the person has a legitimate problem where they can't stop or they need some type of help and actual treatment. It's taking that bridge from just giving them information and hooking them up with actually like a certified counselor who can then kind of help them and be with them on that first really important step of recovery. So we just want to make sure that the kids aren't falling through the cracks. And that's why we thought that at the very least, letting those conversations start with 16 and 17-year-olds is probably a good bet, because if you're looking at the liability of parents' rights versus kind of kids seeking help, I mean, it's a tough call, right? So we thought 16 and 17 is probably kind of the best bet. And that was just kind of an educated call. I'd spent about 14 years working in the General Assembly. So I just thought that might be something that might be explorable.
Absolutely. And do you work with, what is your relationship with schools, high schools?
Well, we always try to provide as much information as we can, depending on different districts. And when we're invited, we love to go in and make contacts. But again, I was the clerk of the Veterans Committee, and I remember trying to use veterans legislation and push that into schools. And we very quickly learned a lot about unfunded mandates and curriculums that were at maximum capabilities. So again, if we're invited guests, we will always show up and we'll use every avenue to go there. But we haven't had a whole lot of success when it comes to trying to mandate any type of inclusion. Although again, we'd love to serve as a resource for guidance counselors. We always have information, and if there's anything we can do to help any students and through information or just even partnering up, feel free to reach out to us.
Yeah, I think that's an important problem, right? We don't want to identify the students or have them self-identify themselves and then not be able to give them the resources that they need. And, perhaps working through schools may be both an opportunity, but also a hindrance, because maybe kids don't want to work with their guidance counselors or, for a variety of reasons. But thank you so much. Those are really important to give us this insight thank you for coming in front of the Children's Committee.
Well, thank you, Representative. I appreciate it.
Thank you, Representative Comey. Representative Wielander.
Thank you, Madam Chair. And hi, Paul. It's good to see you.
Representative?
I wanted to follow up on what Representative Comey was just talking about, because I recently had a conversation with an advocate who was asking for greater awareness of gambling problems. And he mentioned that gambling these days is much more pervasive than we often realize, because when we play games like, I think he used some online video games, when you're doing, playing Candy Crush or just a game that doesn't actually involve money betting, there's still a gamble that can be often involved. And I don't play Candy Crush, so I can't speak to that. But, if you're having your kids are playing Minecraft or some sort of game on their phone and they have to buy a bonus pack, that is oftentimes, I don't want to use the word gateway, but it can be an introduction at a very early age. So I thank you for bringing up the concern about making sure that our students who are 16 to 17 do have access to resources. And that's something I think we should definitely discuss. Is that something that you have had conversations about as well, the early introduction to gambling that the children are getting, not just from scratch offs and lottery billboards and things like that?
Absolutely. Actually, we created a website, gamingandgambling.org, specifically in response to the fact that gambling and gaming has such a correlation now, because whenever there's in-game purchases or limited items, and there's people on the internet, on Twitch channels that are being sponsored through esports and trying to get these lucrative kind of different things. It requires a lot more spending in gambling type behaviors, where people are withdrawing from the normal lives. They're having secondary kind of residencies inside of these communities. They're spending more and more time and resources, less time with their friends and family. So there's a lot of those correlations, and a lot of the actual brain scans show the same thing. And one of the problems with, like, say, gambling compared to like substance use is if a person has a substance use problem and they take a drug, then they get high. But for gamblers, it's kind of an ironic thing where a person gets the same type of highs from almost winning. It's from the actual action of gambling as well as the subsequent wins. So, when you're doing these various kind of loot boxes where you're rolling, trying to get the items that are super rare, it's the same thing as like a slot machine. So those correlations have been worrisome to us. And to be honest, to a lesser point, but we're noticing more and more some of the new behaviors when it comes to high frequency stock pickings, like with like the GameStop kind of phenomenon and things where people are just betting lots of money with very little kind of financial research involved, just on the betting patterns for hopes for huge accolades. It's all kind of in that same vein of worrisome gambling type behaviors that can lead to people into getting themselves in quite a lot of trouble.
Thank you so much for sharing that information, and thank you, Madam Chair.
Thank you. I actually do have one more question. You, I believe, said that when students, when young adults, don't even know, teenagers call the hotline, that if they were asked for a parent's intervention or guidance or whatever, any kind of connection with an adult in their family, that they will hang up. Do you have any idea? Do you track how many of those hangups you have? And just kind of curious how that works.
We can definitely look through our database, but the problem is that they're not actually the ones being treated. It's the parents being treated, and they're bringing the kid with them because the parents are over the age of 18. So we can't refer them by themselves as a 16-year-old to speak to the counselor and then become like the client.
Okay, I'm sorry. Can you say a little bit more about that? Because I think I misunderstood.
If you called and you said that you had you were suffering from a gambling related problem, and we talked about it, and we thought it was valuable to send you to one of our regional health behavior associations or better choice bureaus, and you were going to speak with a certified gambling counselor, they would have an intake form and you become a client of theirs, and they would work with you towards coming up with the best avenue of treatment to help you address the issue. The problem is if you're under the age of 16, you can't become a client. Your mother or father could, and they can obviously bring you, and they essentially get treated through the parents.
So that is a barrier to care, essentially, because then the child is with the parents and they're the ones who are actually entering into a contract with for this counseling.
More just a treatment agreement, but not necessarily a contract. But I mean, just to be honest, going back from my time as a teenager, I made it my mission in life to have my mother know as little as humanly possible anything that I did. So I can understand the cause for trying to bring your mother involved, especially if you've gotten yourself in a position where you borrowed money from the wrong person, or sometimes they have older friends and they're using their sports betting platform, and then they just owe them money, but they can't stop. Or it's becomes pretty complicated pretty quickly on how easy it is to get around some of the barriers if the kid's resourceful.
Thank you. We just had a question for clarification. You're saying under 18 or under 16?
So under 18 currently, but our bill ask would be to make it so 16 to 17-year-olds could speak in their own rights to those counselors.
Got it. Thank you. Sorry to be so obtuse on this. I appreciate your patience.
Right.
Representative Comey?
We're here all the time for you, anytime.
Oh, I'm sorry. Thank you for your second time, Chair. Just a quick question. Are you seeing it younger than 16?
We have, not to a large extent. It's more high school. The gaming stuff, yeah, we are. We're seeing kind of gaming across the spectrum, but also like the question then comes into the access for monies, right? I mean, like certain parents are kind of like, here's my credit card, just throw it on there, just don't do anything crazy. But it really depends on their access to capital, and luckily a lot of kids don't have access to a lot of capital, but they also are kind of trading exclusive skins, which doesn't require kind of capital. It's just kind of like an in-game kind of currency. That's all value based on perception.
All set. Thank you so much. Thanks, Bob.
Absolutely.
Thank you so much for your testimony. Obviously, we learned a lot from this. We appreciate you being here.
No, I'm happy to be here. Thank you so much.
And next up is Justin Carbonella, followed by Andrew Feinstein.
Thank you, Chairwoman Mayer and Chairwoman Lenahan and the distinguished members of the Committee on Children. I'm Justin Carbonella. I'm here in kind of a dual capacity of both being the City of Middletown's Youth Services Director, but also the immediate past president of the Board of Directors of the Connecticut Youth Services Association. I happen to have a scheduled meeting with our distinguished Mayor Ben Florsheim. So he is also with us as well. And if it's okay within the rules of this testimony, he may briefly chime in within my 3 minutes just to say hello. That said, I think it's been clearly stated numerous times leading up to this meeting and during this meeting that COVID has put an immeasurable amount of stress and pressure on kids and community. And as a result, many of them are suffering both visibly and silently. And we believe here in Middletown that this work is really the end of the beginning. And there is important work in the transition from chaos to stability. And that work depends on a level of intentionality and purposefulness that meets the moment that we face ourselves in. And I think we both with Sarah Egan's comments about the CDC's recent study and the words of the DCF administrator who acknowledged that we don't fully know the impact of the pandemic on our kids and families just yet. So that's why we're both here in support of Senate Bill 1005, an act concerning the study of post-pandemic needs of children and the inclusion of a statewide assessment of needs to examine that problem. I will recognize that we are looking to pilot some of this work here in Middletown with the hope that it may be able to be scaled to a statewide effort moving forward. And with that, I'll turn to our mayor.
Thanks, Justin. Thanks, Madam Chair. I'm just here because, as Justin said, we had our regular meeting on this very subject during the course of this hearing. This is something I wanted to be here to say. Middletown, we are taking very seriously as a city. It's something that we are prioritizing. We are directing some of our local ARPA dollars as well as monies that we are getting from the state in various pockets towards this work. And we are just really excited to have this conversation take place at the state level. Want to add our voice to those supporting it. So I'm happy to help answer any questions, but thank you, Justin, for your work and thanks for having us.
Thank you so much. Representative Comey.
Thank you both for joining us, and we're lucky to get 2 for 1 there, representing the city of Middletown. I was wondering who the general task force makeup is, to me, not very clear, and I'm wondering, from your viewpoint, who is best to be a great member of the task force as far as their role in this work?
At least in the Middletown model, we see this as an all hands on deck approach. And I know there was some conversation with the chair people prior to this offering any assistance that the Connecticut Youth Services Association could offer to that task force. I will admit I'm not completely aware of the state's makeup of that, but I would suggest that it is both a mixture of folks who work on large-scale systems level, policy level solutions, and people who are directly on the ground, both supporting folks and those who are I would look to students and family and community members as well.
That's a great point about the community. Do you, what are some of, just because we're a glutton for punishment here in the Children's Committee, what are some of the challenges that you're seeing as gaps and where we can do better for our kids in Connecticut?
So I think I'm both in the dual state of having some personal thoughts and opinions and departmental strategies that are addressing this, and also I'm trying not to get too far out in front of the research. To a question that Representative Linehan asked my counterpart Michelle Piccarello in Cheshire about the what the work is looking like. So I just want to recognize two things because I think that's going to drive to how we find some of these answers. So on one, I want to recognize an existing partnership we have with the Yale School of Public Health to do a literature review of two things. One, examining what the emerging research on the pandemic's effect on kids and families may be. We're seeing that in the CDC report. There's been really interesting research on adolescent brain development that could be fairly scary, still early, but we need to understand this better. About looking at the emerging research on this at a national level. And then the second part is trying to just examine, are there any emergent best practices at looking at the intermediate and long-term harms the pandemic has caused folks. I give the analogy that I knew my grandmother was a depression baby because of every interaction I had with her relationship with food, her relationship with resources, and we saw that decades later. And I worry about our kids. I worry about my own kids. I have a daughter that's as old as the pandemic. And so I just want to, thank the mayor for his leadership and vision here, while also thanking the state for trying to look at this head on. I know we are prioritizing a couple things in Middletown as you do ask that question. One is levels of stress and dysregulation. I think there's no coincidence that we are seeing what felt like anomalies be regular occurrences in terms of accidents and violence and fighting among our young people. I think people are carrying a level of stress that it's unhealthy. I also think engagement is going to be one of those strategies as well. And thinking about how and why young people get involved. We know relationships are one of the best protective factors for toxic stress and trauma. And so we want to think about why young people end up disengaged, and then how we can have a very intentional strategy of getting them. And so what are the combination of barriers that apply there?
I'm just going to briefly add to that. I think that one of the barriers that we've talked a lot about is that the folks who are delivering these services are themselves experiencing lots of barriers, and the need to start thinking about youth serving adults and youth serving professionals, teachers, caseworkers, early childhood providers, really in the same category that we have started to think about medical first responders, public safety first responders. It's the same level of exposure, of stress, of managing new challenges on the front lines of a pandemic, and it is something that the scope of our work needs to include hearing from those individuals as well as from the kids, as the youth themselves, about what is it going to take to try to navigate that.
With the working theory that dysregulated adults breed dysregulated young. That's at the parental level, that's at the educator level, and that's everywhere else that adults intersect and support youth.
That's fantastic. Thank you, Mayor. That's a great observation. And, we see it in our schools, we see it in our homes, and And I love that you're bringing in the engagement, right? You're talking about how to get kids to self-advocate, right? How to get how and why, like you said, they get involved. I was thinking, and it really differs between communities. So what works for Middletown or say a significantly more diverse town or city than it is, more of the suburban towns. I think, I know as a legislator, when I'm sitting here, I hear from a certain, type of child, here today, we heard from kids that have been involved in the system and involved with other types of trauma just because of the nature of the committee. And, in a community like mine or, some of the shoreline communities, we don't hear as much from kids for some reason. And I would love to dig a little bit deeper and find out how we can do better with that, because everyone does have a valuable voice and it only serves them better as they, grow up and mature and become ownership of their own lives. So thank you for that observation. And thank you for being here today.
Thank you, Representative Comey. Representative Wielander.
Thank you, Madam Chair, and thank you, Mayor and Justin for being here today. I really just wanted to emphasize how timely and this conversation is and the urgency in which we need to address this. This is 3 years of a pandemic. We have all seen the impact that it has had on families, kids, communities. So the work that I'm hoping this task force can do is incredibly important. But I also think that because it is such a timely and urgent issue, in my perspective, having read through your testimony and listening to you and other advocates today, that this is something that we need to incorporate as much data as we have right now. And it sounds like your research hasn't, correct me if I'm wrong, maybe you could expand upon it a little bit more. The research that you're partnering with Yale, has that started yet, or is it slated to start soon?
We are, a job has been posted. We've received applicants from graduate and undergraduate students. We are in the interview process now. So I imagine it will start probably within the next 30 days. And from on the research lit review, probably a month after that might give us some definite meat to be able to examine. So I would say between 60 and 90 days out.
That's faster than the legislature works. So I think we can all be in agreement on that. So I would love to have a conversation, and I know Representative Linehan would as well, on incorporating your work as much as possible into the task force and allowing that data to help guide us in our next steps if possible. So thank you so much for being here today.
Absolutely.
So thank you. I really want to make a point to what you said about deregulation. We certainly are seeing it with adults as well. We're seeing it on our roads. In terms of the way people are driving. There's just a tremendous amount of deregulation happening in all of our age groups. So thank you for that. And also the look at the longitudinal component, the fact that, as you mentioned, your grandmother in the Depression and the impact that it has in our worldviews, and children who have grown up inside the pandemic, their worldview was formed by the pandemic. And so any kind of information that we're going to be getting from this study will be incredibly important as we help them develop strategies going forward. So thank you. And Mayor, thank you so much for being part of the conversation. We appreciate you as well. Thanks for your time. Next, we have Andrew Feinstein, and then following Andrew, we have Chris Scott.
Thank you very much, Madam Chairwoman. I'm here in support of 6644, and I want to, well, first, I really appreciate the work of this committee and actually asking questions and probing into matters. This is quite unusual for hearings, and I really do appreciate it. I apologize very much for not being there in person. So on 6644, we've heard objections from some administrative agencies and from birth to three providers. 2 points fundamentally. One, this seems to be a real misreading of what the legislation says. It says, in line 70 and 71, that the individual service provider will inform the parents of, quote, rights and resources available to such child in the provision of special education and related services. That does not take a comprehensive knowledge of special education. That takes a basic knowledge, and I'll tell you that my colleagues and I would be delighted to provide whatever training is necessary free of charge to any birth to three provider who they think needs it. But in dealing with birth to three providers, I don't think they need it. I think they know the basic structure of special education law. The concern I have is that according to the figures that Cindy Jackson provided, 30% of kids who are birth to three go on to be not eligible immediately. I will bet you if you look longitudinally, that the vast majority of that 30% become eligible shortly thereafter. Second, the other point about that is that even when eligible, the services provided to our 3-year-olds and 4-year-olds are really trivial. There are a lot of related services, very little in terms of educational services, yet the data, the research is quite clear that those ages are the ages where children learn to learn, where children learn the brain structure necessary to develop the skills to be successful learners. The fact that we're providing almost nothing for them during that period is really a shame. And having the birth to three providers provide support and speak up at PBT meetings would be critically important. Further, the population we're talking about are a lot of parents who really do not have the knowledge or the ability to advocate on their own. And they look to the birth to three provider as the person who can really help their child. Having the birth to three provider send them to CPAC, which is available and some parents do use it, but having a trusted person say, I can't help you, go to this state agency, quasi-state agency, really strikes me as not helpful at all. I guess that's, if we need to make this clearer as to what the language says, we're glad to work with you on that. But I think that the language itself is perfectly fine now. The other premise of the testimony of the agency heads and Ms. Jackson was that school districts are the ones who decide this. And there's sort of this notion that the decision on eligibility is it's just a clear black and white decision. Well, it's not. As you all know, probably better than I do, local school districts are under serious pressure to reduce the number of special ed eligible kids. And unless there's advocacy for that, these kids are not going to get the services to which they're entitled. And so this notion that we should collaborate, we should rely on local school districts. Well, in cases you can, but in a lot of cases, that just means that kids get kicked to the curb, do not get the services they need. 6644 is good legislation as it now stands. If it needs changes, glad to work on that. But I do think that the objections raised by Commissioner Russell Tucker and Commissioner Bai and by the representatives of the birth to three providers are not solid and should not be treated as such. Thank you.
Thank you for your testimony on this. Obviously, there's going to be a lot of conversations afterwards, as we have heard from many differing opinions about this. Representative Comey.
Hello, Andrew. How are you?
Good. How are you?
Good. My question for you involves the new online system that was mentioned in previous testimony. Can you share what your experience with your clients has been?
let me be brief about this because I can go on for hours about CT SEDS. CT SEDS rollout has been, nothing short of a disaster, but that's a lot of technical problems. The basic concept of CT SEDS is good, but the materials are not terribly, they may be slightly more accessible than the previous form, but they're still not very accessible. It still takes somebody with real knowledge of the system to be able to read an IEP off of CT SEDS or to understand what forms need to be filled out under CT SEDS. It does not, for a person entering the system, it does not make it any more accessible a system, CT SEDS. Moreover, it's a computer-based system. And so for parents who are not sophisticated with the use of computers or may not have the connectivity necessary, CT SEDS may not be helpful at all. That said, I'm glad we're moving towards CT SEDS. We just moved towards it too quickly without the bugs being worked out.
Thank you. Do you have any comments about any of the other bills?
Yes, my general comment is whatever Sarah Egan says, I agree with.
I think we all are in that party.
Thank you.
Thank you, Andrew.
Appreciate it.
Thank you, Representative Comey, and thank you for your testimony today, Andrew. We really appreciate you and for your offer to help as we go forward.
Thank you.
Do we have Chris Scott? Oh, hi, Chris. Do you want to turn your mic on? There's a button right there.
Got it. I'm just going to set a timer so I can keep an eye on that. Good afternoon, distinguished members of the Children's Committee, General Assembly. I really appreciate your time today and all the work that you guys do. I've definitely seen the late night cars in the garage pictures on Facebook, so I know how much time and energy you put into this work. So thank you. My name is Christopher Scott. I serve as the executive director of Sun Scholars Inc. We're a 501c3 nonprofit organization that serves statewide. We contract with DCF and we work with foster and adopted individuals, young adults who are going to college or trade school and the ages of 18 to 23. On that premise, I'm here specifically to speak on Senate Bill 1008 on behalf of legal representation for youth and extended foster care with the Department of Children and Families. And I come to this both as a professional, as an executive director of an agency, but also as a former foster youth, having spent the vast majority of my life in the system prior towards college and fancy titles and all that good stuff. This is such an important bill. The work that Stacy specifically has done, I want to really highlight. Her agency, Center of Children's Advocacy, is pro bono doing a lot of the work at a lower scaled level because of funding that this would essentially allow. I can't tell you how many times I've sent a student to Stacy. I want to give you some examples of instances that I saw lives change because of her agency and her work entirely for free and pro bono. I once had a student that was a witness to a murder in their younger years. They were subpoenaed later on, had nothing to do with this murder. They were in foster care. They weren't eligible for a lawyer because they were over 18. And Stacy was able to consult on this individual who had done nothing wrong, wrong place, wrong time, and was able to get them the guidance and advice they needed to get out of this very, very challenging moment in the course of their career. Another student that was by all definitions eligible for college funding that for whatever reason, and a surprisingly more contentious path than it should have been, wasn't being able to get these resources. And Stacy's agency came in, and I'm proud to say that that student is still enrolled at Sun Scholars and is pursuing their career in college because of her and the work that they do. I can give you the list on. I've sent people that had parking tickets to all the way to that murder incident to Center of Children's Advocacy. I think it really comes down to, it's not why we should do this bill, it's why we shouldn't. If you look at all the other states that are doing this, Alabama, Alaska, Arkansas, California, Colorado, I can sing a song. Right? We're better than these guys. We should be really fighting for the best things that we can do for for our state, for our children, for the youth. That's what it's all about, right? And if we don't believe that, then, we're probably in the wrong place, right? We should probably make in Connecticut the best place, which I know you guys are all doing. I really believe in this bill. It means the world. I've seen it in action, or at least what it could look like for our youth that are in ages 18 to 24. And it would really allow for them to become the future taxpayers and members of our state. So I really offer my gratitude again for the chance to speak behalf. I'm happy to answer any questions you all may have. 3 minutes and 7 seconds. Pretty good, right?
Awesome job. Okay. Any questions? No? Yes. Representative Lanu.
Thank you, Madam Chair. Good afternoon, sir. I just want to just make sure I'm clear what the intent of this bill is. So essentially, if the example you used about the youth, the minor who witnessed murder when they were a youth, they were now in adulthood, and the proceeding was moving forward after they crossed the age of majority, they would still be able to, they'd be entitled to representation that would that they would have gotten when they were a youth. That would continue until the proceeding was over. So even though they crossed the age of majority in that time period, they would still be entitled to legal representation. Am I understanding that correctly?
So to my knowledge, I'm 90% confident on this. Had they been 17 and at that moment in time they had a lawyer and they had legal representation, and then once they turned 18 and then 19 and they were in college, they were no longer eligible for that representation. But Stacy and Center of Children Advocacy pro bono came in and was able to support this individual, which I believe the goal would be to have this bill, if passed and gone through the floor and signed into law, would have essentially allowed for, some compensation to occur for the Center of Children's Advocacy, which to me is so important because they're obviously not doing this for money, right? Like, I don't run a nonprofit to be rich. That I think that's pretty clear. I have an Apple Watch and that's the best I'm ever going to wear. We do this because we love the work. We do this because we love the mission. And, pro bono, you can only do so many cases, right? So if this bill comes into law, imagine how many other hundreds and hundreds of individuals. We know there's at least 400 kids, young adults in extended care at any given time. So many more individuals that run into these issues that don't have support would get support. I don't know about you guys. I don't want to rant, but when something goes wrong as a kid, or if you guys have kids and something goes wrong, what happens? They go to you guys, right? They go to us, the parents. I think it's crazy. And I feel privileged to be in this position, but I'll get texts from students. I'm like, wow, if I'm getting a text from this student in this issue, or one of my staff are, that says something that us as nonprofit full-time employees, if we're the first person they're going to, they don't have a lot of people in their corner, right? That really says something to me. So I think this bill would allow for those individuals, and then I call Stacy because I'm not a lawyer. So, this is one of those areas that I think we really can help a lot more individuals that are just falling entirely between the cracks.
Now, you're talking about somebody who was like a witness, a minor that was a witness to a crime, or now if suppose they were an offender themselves, would that fall under this as well?
Yeah, that's a really good question. I don't want to speak too much on that because I would want to defer to Stacy and other individuals that are architects of this. But to my knowledge, yeah, they would have some representation. When we think about the child welfare population in particular, right? We're talking about my community of foster and adoptees. 3% of us graduate college. We're overrepresented in prisons. We're overrepresented in drug and alcohol use. We're overrepresented in a lot of the negative statistics that exist in this world. And so when we think about this, some people make these decisions circumstantially, right? They haven't had the guidance or the support of, a traditional household or even just good mentors in life. And they might make a decision. I've had students that got speeding tickets. They were driving 100 miles an hour in another state, and I didn't know what to do. And so, we contacted Center of Children's Advocacy, and they knew they were in the wrong. But it's like, is this person now who's going to college, doesn't have any supports, trying to do the best they can? Are we going to hold this one decision against them and prevent them from all the other things they can accomplish in life? And maybe the answer is yes, right? But at least, they have someone to go to and they have that consultation and support to get through that really difficult moment. I can say right now, I would, I went to Tungus, Central, Harvard. I have a house, a wife. It's crazy. Had I not had the mentors I had growing up, both legal and non, I would not be here today in front of you guys. There's no reality I would be here. So I think about, and I haven't made perfect decisions in this life, but I think about, you know, thank God in those decisions, I had people that helped lift me out of it. And I see that this bill as maybe I'm celebrating it more than it could be, but I think it offers the right step in the right direction to make sure more people, especially in those developing years, you know, the brain's not ready till 25 to make good decisions. In those 18, 19, 20-year-old years, we can get people out of the pickles they might fall into, if that makes sense.
All right. Well, are you looking for people once they cross the age majority? You know, you mentioned 18, 19, 20. If they offend during that period, you think they should be entitled to some sort of counsel as if they were a minor?
In the definition of as if they were a minor, I would say I believe they should be entitled to the same support they would have had prior towards aging out of child welfare. And what I mean by that is, so when you're in the foster care system, 0 to age 18, or, you know, 18 minus a day, 17 and so on, you know, you have a lot of benefits in the sense that you have legal representation, you have a lawyer, you have access to, you know, programs that Emily shared earlier today, you know, such as life skills and coaching. A lot of those programs actually sustain past the age of 18. You know, I'm a benefactor of, you know, the tuition subsidy that existed, you know, having gone to Central. It's interesting because then, you know, we see other services phase out, right? Such as the right to, or not the right to, but the ability to have legal representation through the Department of Children and Families. So even though you've, you know, maintain yourself signed in to extended care, so you still by all definitions are a quote unquote, you know, ward of the state or foster youth at age 18, 19, 20, just you're voluntarily signed in at this point. It makes sense to me that that would be one more, you know, service that does continue for this population that, you know, to paint the picture, right? Very literally, you know, our students, thinking right off the top of my mind, we have students 19 years old, probably some scholars might be some of the only supports they have. So, you know, God bless, we're like kind of their moral compass sometimes. And they're living in an apartment by themselves and going to college. Just think about that. A 19-year-old living in an apartment by themselves, taking care of their own bills, having autonomy of every hour of their life with no traditional supports. That's a lot. That's a lot to handle. As a former 19-year-old in that position, I can say it's a lot to handle. And so, you know, mistakes can happen, and not just mistakes, but sometimes, you know, when you think about all the other entanglements that occur from the life that we come from, you know, coming from families of generational trauma, generational drug abuse, these things might trip up. And so I think that this extension of legal supports can really help out this population of 18 to 23-year-olds. Not to say that 18 to 23-year-olds are angels, by God, they aren't, but it is the right decision in my mind to be able to make sure that they become, you know, adults. And in speaking of dollars, just to add this one comment in, my wife and I pay every year probably between $40,000 and $50,000 in income tax. My wife's way smarter than me. She's an amazing job, so she has more taxes than I do. Think about that, right? Just to give this sum. In total, right, the state of Connecticut compensated probably around $70,000 towards a college tuition for me when I was in foster care. I've paid that off tenfold by now, and I'm going to pay it off 100-fold, hopefully, right? So I see this as well as an investment that correctly lines up with our most vulnerable population, getting through a very vulnerable period of their life that, you know, the brains aren't fully developed. Not to belittle that, but it's just the reality. You know, 18, 19, 20-year-olds are way more willing to make risky decisions than 25 and older. I can say right now, there's a lot of things I do today that I did back then that I would not do today. Right. So like skateboarding, right? Skateboarding is pretty dangerous. So really the dollars and cents that we look at this, to me, it makes sense as an investment in our state's, you know, future taxpayers. And the benefit is compounding, because not only is it a benefit in terms of taxpayers, but it's taking people from the most vulnerable population and turning them into a productive population, if that makes sense.
Where would you draw the line as far as for an age? What should be the age cutoff?
Yeah, to me, you know, so in my ideal world, I would put everything to 26. Like foster care, everything. In my pragmatic world, that will never happen, right? That's not going to happen. So as the pragmatist that I am, I think 23 is a perfect cutoff, because 23 is when extended care already in the state cuts off. So 18 to 23 is when the age parameters around extended care. It's actually the age parameters that we have at Sun Scholars Inc. We align right with the Department of Children and Families. We'll work with young adults up until the day before their 24th birthday. So to me, that makes a lot of logic. So I shared my idealism, which I hope doesn't get taken too much internally, but pragmatically and responsibly, I think 18 to 23 is a parameter.
Yeah, well, I want to first of all, excuse me, congratulate you on your success. You're certainly a role model for many young folks, and
Thank you.
I really admire you for coming over your obstacles. So you have to be congratulated for that, and thank you very much for your testimony. I mean, I'll certainly say I certainly agree. If a minor is a witness to a crime, is some sort of a victim of a crime, the case isn't disposed of until they cross the age of majority. Certainly, they should be entitled to that legal advocacy. I'm not sure once we start getting into if they start offending after the age of 18, being able to get this representation on the state's dime. I think that might be going a little far, but
Sure.
I will be happy to look at the language, look at the final product, and I do thank you for your time, Madam Chair. I have nothing further.
Thank you so much, Representative Lanu. If I could just clarify it as I understand it, when we were speaking with DCF a few weeks ago, there was a conversation that at the age of 17, you have to decide, you start having conversations. Are you going to stay connected to DCF after age 18? And not every foster child wants to do that. And what I understand is that there's a cohort of maybe 300 to 400 who do decide to do that. And when asking, and usually it's because there's a variety of reasons, but one of it may be college, attending college and having that extra help. The other part of it, though, is in talking with the commissioner, it seems as though only a percentage of those cohort actually access services. So we're not talking about all the children, all the people in DCF in foster care. And we're not talking about even everyone who agrees to stay connected after age 18 is the way I understand it. So I just wanted to clarify those two pieces. And I really didn't have a question for you other than to say, thank you so much for your testimony. And Representative Wieslander, you did have a question.
Thank you, Madam Chair. There were two things I wanted to point out, an additional clarification. One being that I think when we're talking about the representation, and again, correct me if I'm wrong, anyone who has this information, it's not for like the Sixth Amendment type of legal right to representation if you do offend. It's more legal representation if you are signing a contract for a lease on your own apartment, or looking to sign some sort of official bank statement for college loans or things to that nature. Is that more the type of representation that we're discussing for this case?
Yeah, definitely. I think I use some relatively radical examples for the sake of awe and shock, because I think that is soluble. But more often than not, I probably imagine 99% of the time, this bill would actualize as supporting individuals as they kind of navigate those decisions, whether, like, perfect example, signing a lease, right? Making sure they're not getting into something that's going to take advantage of them. Being able to, and I can tell you right now, we've had students that we've sent over towards Center of Children's Advocacy that had been signing leases, and we're like, hey, let's just get an extra eye to comb this over because we want to make sure that this is going to be effective. A lot of times we see with our individuals, when we send them over, it's in regards to their funding at the Department of Children and Families, how to navigate some of the policies that can become a little bit, I have a whole master's in government, and sometimes things can become a little nebulous, right? So I think that happens a lot with the students and the youth. Additionally, a lot of issues with the students surrounding, one of the big things that we see in the child welfare community is a lot of fraudulent use of people's names. A lot of foster and adopted youth will come into some pretty serious financial entanglements and no fault of their own. I'm going to keep this relatively anonymous. I'm going to use fake countries and whatnot, but I had a student that their parents took out a loan in another country in South America, and essentially this student who's in the Department of Children and Families and Extended Care goes to, open up a credit card or something. And somehow this was just totally missed. And during normal regulated credit checks at the ages of 17 and 18, because it was just out of the whole country. That's a bad place to be, right? Having $300,000, $400,000 in debt in your name as an 18-year-old, you're just trying to open up a safe bank card at like TD or whatnot, right? So that was pretty scary. And we sent them and things had moved forward progressively in a correct motion. And I think most of that was actually remedied. So that's more kind of the kitchen table issues that I think 99% of this bill would go towards supporting, which is why I also really believe in it, because again, I'm not a lawyer, and there's a lot of times that legal representation I find is needed, especially on contract and leasing and debt that has been accrued due to fraud. Those are definitely the issues that I imagine Center of Children Advocacy faces the most as well.
Okay, thank you for that clarification. I just want to make sure that,
Oh,
'cause
of
I think
course.
otherwise we'd be going into judicial. We're not there yet.
Yeah. Sorry about that. I didn't want to
No,
derail.
That's fine. The other point I just wanted to make, to tie it back to, I guess this might be more of a comment than a question, but to tie it back to some of the information that Sarah Egan shared earlier in the day, that the recent study on what is the study? I can't remember. Adverse childhood experiences.
Oh, the ACEs?
The youth risk
Yeah.
assessment. Thank you. It's been a long day. One of the things that she pointed out as being a rising concern is the lack of the children having a lack of connection, not having that one person, a trusted adult that they can turn to in moments of crisis. And when we are discussing children that have that are already in situations that put them at higher risk for things, as you mentioned, to be able to turn to someone that they can trust and who can legally guide them in the right way, I can only imagine how helpful that would be, especially in moments of crisis. And so I think that's just another point that we might want
Yeah.
to remember as we discuss this further.
If I can speak on that very briefly, I mean, I look at Stacy's influence on the young person today, but also other students that I've been having the privilege to send her way. And just in my connections with students, it does not go past me the immense responsibility it is of us to be positive role models for these individuals. And very much, we are the first light in many cases that bring together a dark room and show people the path. I can't tell you how many times we've seen students get caught up in multi-level marketing schemes and all these other, nebulous, nefarious issues because, vulnerable, don't know where to look. Role models come out enticing, positive, charismatic, and before you know it, you're in a really bad situation, to be frank. And so again, having someone that is rubber stamp approved, right? This is a lawyer, that's receiving funding from the Department of Children and Families. They're here for your best interests, not any other reason. I think that's really important because, especially when we think about ACEs and adverse childhood experiences, this 18 to 24 population, without a doubt, is resilient, right? Incredible degrees of resilience, but also we're behind, right? Developmentally, trauma impacts you in a lot of weird ways. And so, 19, you might be very vulnerable. You may not have the right people, and it's very easy to fall in the wrong places. And so, again, I think that having that one more structural support really does matter for the young people in this particular slice of the child welfare population.
Thank you for that. And thank you, Madam Chair.
Thank you, Representative Wieland. Thank you so much for your testimony. Thank you for staying till the end. And thank you for the passion with which you spoke for this support for this bill. We appreciate you.
Thank you. It's a pleasure.
As we have no other people waiting and we are finished with the hearings, then I don't know the formal language, but we're adjourned. Thank you.